Good morning and welcome everybody. It is now 10 a.m. and I would like to formally open this specific issue hearing 10 for the Mooir Vannin Offshore Wind Farm project. Before we introduce ourselves, just a few housekeeping matters. Can everybody in the room hear me at the back? Thank you. Live stream and recording. Have they started, Mr. Randall? Yep. Okay. And can everyone present in the room please set all their devices on silent? Okay. Toilets are to my right through the double doors and there are no planned fire drills. So please leave the building by the nearest fire exit and collect in the car park should you hear an alarm. On to panel introductions. My name is Ms. Sahai. I have been appointed under Section 27 of the Marine Infrastructure Management Act 2016, or MEMA, to chair the panel of examiners for this application. I confirm that I've made a conflict of interest declaration as part of my appointment. My declaration of interest and that of my panel colleagues was discussed at the preliminary meeting on the 3rd of March 2026 and subsequent hearings and meetings. Anyone who wishes to do so may review the published recording of those events for our full declaration. I'm a chartered member of the Royal Town Planning Institute, which means I'm bound by their code of professional conduct, including the requirement to operate with honesty and integrity and to exercise independent professional judgment. This underpins my commitment to conduct these proceedings in a manner that is independent and procedurally fair to all. I will now hand over to my fellow panel members to introduce themselves.
Good morning. I am Frances Fernandez and I am a panel member appointed pursuant to Section 27 of MEMA. I confirm that I have made a conflict of interest declaration as part of my appointment, and I am also a fellow of the Royal Town Planning Institute, which means I am bound by the Code of Professional Conduct in the same manner as it does to the other panel members and frames my conduct in this examination.
Good morning. I am Ms. Powell. I am a panel member appointed pursuant to Section 27 of MEMA. I confirm I have made a conflict of interest declaration as part of my appointment. I am also a chartered member of the RTPI, which means I am bound by the Code of Professional Conduct in the same manner as it does to the other panel members and frames my conduct for this examination.
Good morning, everybody. My name is Mr. Smith, and I'm a member of the panel appointed pursuant also to Section 27 of MEMA. I confirm that I too have made a conflict of interest declaration as part of my appointment. I'm also a chartered member of the Royal Town Planning Institute, which means that I'm also bound by its Code of Professional Conduct in the same manner as it binds the other panel members here today, and it frames my conduct in this examination.
Thank you. Also present are members of the Cabinet Office case team, Mr. Tom Randall, who provides procedural support throughout the examination process, who's supported by a team. Audiovisual service is provided by Energy Media Limited. Just a few words about how I intend to run the meeting today and the purpose of the hearing. Today's hearing is being undertaken in a hybrid way, meaning some of you are present with us at the venue and some of you are joining us virtually through Microsoft Teams. Some of you are watching live stream. A recording of today's meeting will be made available on the MEMA website as soon as practicable after the meeting has finished. And from that recording, we intend to extract a transcript for the examination record. With this in mind, please ensure that you speak clearly into a microphone, stating your name and the organization that you're representing each time before you speak. If you're not at a table with a microphone, there are roving microphones, so please wait as one of these will be brought to you before you speak. A few words about personal information. When speaking, do think carefully about your personal information. If you feel a need to refer to something of a personal or confidential nature, please remember that anything you do say will be included in the published recording. The Cabinet Office is administering the consenting process for applications made under MEMA, and in that regard, it will process personal data in accordance with the Data Protection Act 2018 and GDPR and LED Implementing Regulations 2018. For more information relating to your data protection, please see the Cabinet Office's privacy notice or speak to Mr. Randall if you have any questions. A few words about the statutory framework of the hearing. Under Section 31 of MEMA and Regulation 31 and 34 of Marine Infrastructure Consenting Process Regulations 2024, the examining body can hold specific issue hearings if we think a matter requires cross-party discussion and to ensure that principal stakeholders have an adequate opportunity to state their case. The examination under MEMA is an inquisitorial process, and it is for the examining body to lead the questioning in order to test the evidence before us. For the purposes of this hearing, I will not allow cross-questioning between parties. If parties consider that further points need to be explored, they should indicate this to the examining body, and we will decide whether those matters are pursued at this hearing today or later through the written responses from applicants. Now on to today's hearing. Today's hearing is specific issue hearing 10 on the draft Marine Infrastructure Consent and Strategic Matters. The examining body notified parties of its intention to hold specific issue hearing 10 or SIH 10 in its Regulation 31 letter issued on the 26th of June 2026. And the detailed agenda was issued on Friday, the 3rd of July, 2026. We notified parties of some minor revisions to the published agenda. We will cover economic effects, employment and skills, which was held over at SIH 8 in session 3 after agenda item 7. And in session 2, I'm hoping to cover a few items relating to the applicant's proposed amendments in relation to the thought experiment, Scheme 1 and Scheme 2. As you can see, it is a very full agenda, so we will move at pace. There have been some requests for last representations, closing remarks, and we'd just like to remind parties that we're still 2 months from closing. This examination remains open until the 9th of September. So this is not the opportunity to do that. The opportunity to do that will be in the final few deadlines. And deadline 9 is the same day as the close of the examination, which is the 9th of September. So we will not be taking any closing remarks because this is not the opportunity to do so, and there are several opportunities left in the examination. With that, I will move on to introductions from attendees. Very quickly checking across the room if there are any members of press attending today. No, I don't see any hands up. Okay. And just then turning to all of you present, turning to the applicant first, if you can identify the person leading today and then just introduce the key persons in your front bench, and we can go through introductions later on.
Thank you. Good morning, Madam. My name is Amy Sterling. I'm a partner and solicitor at Pinsent Masons, and I'll be representing the applicant today. I'm also joined by my colleague, Mr. Toby Yates, who is an associate at Pinsent Masons, also representing the applicant today. And I'm also joined in the table with Dr. Julian Carolan, also representing the applicant. I have only 2 colleagues joining online, so if it helps, I will introduce them now. Mr. Ian McKenna is currently online. He's Head of Land and Property Europe at Ørsted. And joining at around 11 a.m, I have Mr. Simon Fox, who's a Senior Commercial Project Manager at Ørsted.
Thank you very much. From Department of Enterprise.
My name is Richard Oliphant. I'm representing the Department for Enterprise today.
What I would recommend is if you come forward to exactly where you're sat for session 2, I think that's where we will be seeking most input from you. Thank you. Department of Infrastructure.
Good morning. My name is Robert Garden, a partner and solicitor at CMS, and I'm representing the Department of Infrastructure. I'm joined today by Ian Brooks, who is the department's Legislation and Policy Manager, and by Emma Rowan, who is the department's Senior Infrastructure Policy Officer.
Thank you, Mr. Garden. From DEFRA, Mr. Mill.
Good morning. Ken Milne here, representing DEFRA, and I'm joined today by my colleague Richard Armitage.
Treasury.
Hello, Jonathan Platten, Head of Economic Advisory at Treasury. I'm joined by my colleague David Parsons, Deputy Assessor at Income Tax Division, Treasury.
Mr. Parsons, again, I think session 2 will be the most suitable time for you to maybe join us at the table. But if there are other items in the agenda that you feel you can contribute to, then do indicate at any time. Thank you. Is there anybody here from the Cabinet Office? Ms. Brown? No. Okay. GARF Commissioners? Can we make sure the roving mic is available?
Yes, good morning. I'm Richard Henthorne. I'm Chairman of GARF Commissioners. And I'd just like to ask a point of order, Madam Chair.
Sure.
Amongst the things to be read out is our summary of statements, and you were saying earlier there'd be no opportunity for closing comments, but I will get the opportunity to summarise those the comments within that. Will I? I've certainly prepared something to say.
Is that relating to any items in the agenda today?
It's related to D4, item 150, which is the summary of comments, which was noted down in the agenda today. I'd certainly like the opportunity to put that point across.
That point is noted, Mr. Henthorne, and I will have a look at the document reference number that you've just given. If it relates to the agenda that we've got today, I'll definitely give you an opportunity. However, if it does not relate to the agenda today, then we will request you to either put that in writing in the examination.
Sure, that's fine. I would really appreciate the opportunity to read it amongst the sort of the gathered people, because after this meeting there are no more meetings in which everybody is together, and the submissions may not be sort of heard by the general interested parties, more or less just the board or the members.
That's noted, although that the examination library is open to everyone. So, and given that written representation's the primary way to conduct the examination, you should be rest assured that anything in writing that comes in after this point, there's still 2 months, 2 valuable months of the examination still left. Okay, but thank you for making that point.
Thank you.
Okay. Okay. Manx Wildlife Trust. No. BAE Systems Operations. They might be online.
Hello. Hello, this is Rachel Ward from BAE Systems Operations.
Hello, Ms. Ward.
And we also have legal representation on the phone as well.
And is that Ms. Grange?
Yes, ma'am. Good morning. Samantha Grange from Evershed, Sutherland, representing BAE Systems Operations Limited.
Thank you. And BAE Systems Marine.
Hello, this is Rachel Ward again. BAE Systems Marine will come on as required, so they're not going to sit here all day, but when required they can pop on.
Okay.
We also have our technical SME on the line as well.
Okay. Miss Ward, just to let you know that we can hear you clearly, but your video is not turned on.
Thank you. I'll sort it out.
Okay. All right. And then MCA?
Good morning, Nick Salter from the Maritime Coast Guard Agency.
Thank you, Mr. Salter. And then Burgess Salmon on behalf of Mona Offshore Wind Limited.
Hey, good morning. My name's Patrick Monroe. I'm a partner at Burgess Salmon and I'm representing Mona Offshore Wind Limited.
Okay. And Flotation Energy for Morecambe Offshore Wind Limited.
Good morning. My name's Oliver Gardner. I'm asked to be representing Morecambe Offshore Wind Farm Limited. Thank you.
Hello, Mr. Gardner. DLA.
And for the record, I know Mr. Gardner as I have previously worked with him in a professional capacity, but not in relation to this application, the applicant more generally, or in relation to any interested party. I can confirm that no discussions concerning this application have taken place either before, during or after this examination. Thank you.
DLA Piper for Walney Extension, Walney Offshore Limited, and Wards Holdco.
Yes, good morning, ma'am. Michael Gregg, DLA Piper for Walney Extension Limited, Walney UK Offshore Wind Farm Limited, and Orsted Schroders Greencoat Wards Holdco Limited in relation to their interest in West of Duddon Sands. Could I just clarify at one point, ma'am, from what you said earlier on in relation to the thought experiment? Am I right in understanding there that the thought experiment that you were referring to is the same thing that's within the applicant's document without prejudice indicative alternative layout that they lodged at the last deadline?
Yes, it is. Yeah, there's a few documents that have come in over deadline 5 and deadline 6. But yes, that is the latest one that you've just referred.
Yeah, it's just to clarify, madam, we may have something to say about that in due course.
That's noted. Yeah, okay. Thank you. And then Mr. McNamee.
Good morning, Anthony McNamee for Scottish Power Renewables in respect of their share in the West of Duddon Sands offshore wind farm.
Hello. Okay, and then not for Isle of Man. Okay, we'll come back to that. And now I'm just taking names of persons who've registered and expressed an interest to speak. Dr. Alex Allenson.
My name is Dr. Alex Allenson. I'm the MHK for Ramsey.
Ali Strafford.
Yep, Ali Strafford, we've met before, resident of the Isle of Man.
David Owens.
Good morning, my name's David Owens. I am a Chartered Accountant and past Chairman of the Isle of Man Society of Chartered Accountants.
Hello. Donna Bailey.
Brian Bailey. I'm a resident of the Isle of Man.
Ian Strafford.
Good morning, Ian Strafford, resident of Laxey. Thank you.
Janet Clark. Perhaps online. Okay. Julia Cregeen.
Hello.
Sorry, yes. Hello, Ms. Clark. We saw your hand up, so we thought that that was you nodding your presence.
Sorry. Hello, Janet Clark, resident of Andaman.
Okay.
Thank you.
Julia Cregeen.
Julia Cregeen, resident of Laxey.
Julie Edge. Not here. Patricia Newton. Hello. And Peter Taylor. Not here. Not for Isle of Man. Miss Sullivan, are you here? Okay, good. I think that completes all parties who have registered to speak. I've seen a hand up. Could you take the roving mic, please?
Yeah, Madam Chair, I was under the impression that I'd been registered to speak on behalf of the Garth residents.
We took an introduction from you earlier, Mr. Henthorn.
Just double checking.
Yeah. Okay, right. That concludes this agenda item. We'll swiftly move on to draft marine infrastructure consent. And as I said when the agenda was issued, there's a number of matters relating to the draft marine infrastructure consent that remain under consideration for deadline 6. But this agenda was, of course, issued in advance of D6. So there are a few matters, additional matters that have been identified since this agenda was issued. So bear with us and let's hope we can have a full discussion on everything. I'm going to start with Article 3.2. So first is just a point of clarification. Article 3, paragraph 2 appears soon after works plans, but it is not related specifically to, exclusively to works plans. It is its own provision. Am I correct in that assumption?
Toby Yates on behalf of the applicant, that's correct. So Article 3, subparagraph 1 sets out a full list of defined terms.
Yeah.
And then subparagraphs 2 onwards relate to the remainder of Article 3.
Fine. So now Article 3.2 provides, and I'm reading this verbatim, references in this order to rights over land include references to rights to do or restrain or to place and maintain anything in, on, or under land or in the airspace above its surface, and to any trusts or incidents, including restrictive covenants to which the land is subject. The applicant, you've repeatedly confirmed that you're not seeking CA powers, but if you could just explain why Article 3.2 is required and identify the provisions of the draft MIC to which it would apply? Because as drafted, it appears that the MIC would give you powers to interfere with private rights.
Toby Yates on behalf of the applicant, that's a hangover from the template initial draft DCO from Hornsey 4 that we'd used as the basis for the MIC and can be removed.
Okay. All right. And then let's just... Yes, madam? So, as I said, that for the first agenda item, there are a few additional matters that I will be covering because the agenda was issued before the last version, the latest version of the draft MIC was issued at deadline 6. So this actually, the very first item that I've started is not on the agenda. It's Article 3, paragraph 2. It's page 11. And then Article 3.5, my main concern was the interaction between 3.5 and Article 3.2. But generally, it says that Article 3.5 then provides the word includes is not limiting. It basically says Article 3.5 says that the word includes is not limiting. And so once again, just a question of what provisions in the draft MIC would it apply to? Do you need it? It just seems to me like 3 and 4, like 2 and 5.
Toby Yates on behalf of the applicant. We've done a quick search now, given it's a new point being raised and it's not referenced too frequently, but we'll have to take it away and just check there's no consequences.
Yeah, okay. All right. Let's move on to Article 6. And again, I'm not going to rehearse what's happened during the course of the examination, but just start from the position now. So the examining body is not convinced with the justification for allowing transfer or grant of the benefit without approval, because CA powers is not just the only thing that needs to be tested, because when you transfer controls, you need to ensure that the transferee is technically and financially capable. There's accountability, protecting national interests, and so on. And comparable offshore wind farm orders that don't require CA do require consent from government departments. So just, you know, how, and this is a matter that's of course been raised by DOI as well. So are you willing to include a provision to seek permission from DOI before the transfer of benefit?
Toby Yates on behalf of the applicant. So the position of the applicant today remains as set out in previous submissions. And as you've alluded to there, it's effectively that the fact there is no compulsory acquisition powers in the marine infrastructure consent, that's analogous to all of the exceptions in well-precedented development consent orders, whereby the justification for Secretary of State consent in that instance is on the basis to give comfort as to the liability that may arise in relation to compulsory acquisition powers. So in absence of those powers, there's therefore no need for consent, although taking the body's point, we'll take it away and can discuss that further with the DOI after this hearing, but the position of the applicant remains as previously set out.
Okay, so I'm now preparing for examining body's commentary on the draft MIC. So what I'm going to do here is that I'm going to ask DOI to provide some draft wording of what you would like inserted. And if I could have that either as a hearing action, if you can do it by Monday, but we do now have the gift of this Reg 31 deadline for Friday. So if you can provide that wording, in the absence of receiving anything from the applicant, we'd like to use that in our commentary.
Robert Garden, on behalf of the Department of Infrastructure, we can provide that wording. Just one point of clarification, I think we would seek to have the approving body be the Council of Ministers, potentially with the Department of Infrastructure as the consultee. Thank you.
Okay. Okay. Now, the next agenda item is going to take a while because I've pulled together the full package of what comes with the definition of commence, the permitted preliminary works, and the pre-construction survey plan. So let's just start with the definition of commence. Now that separates the commencement of the onshore works from the commencement of offshore works, and this is to prevent minor onshore operations from inadvertently triggering the requirement applicable to the offshore works or vice versa. Seems sensible to me. Parties agree?
Yeah, Robert Garden on behalf of the Department of Infrastructure. Yes, we agree.
Okay. There was an earlier reference to material operation, which I believe has now been removed. Department of Infrastructure, you're all right with that?
Yeah, Robert Garden, on behalf of the Department of Infrastructure, we are happy with that because it removes kind of questions as to what materiality means.
Good. So there's no point, there's no outstanding need to define material operation. So that's done. Now, permitted preliminary onshore works. DOI's position is that it's broadly appropriate, but you wanted particular activities controlled. So just to confirm, this includes archaeological investigations, which are specified through controls in requirement 30, and creation of site accesses, which has now been controlled through requirement 32. Beyond these two activities, can the applicant and DOI, or indeed any other parties, identify any of the other remaining categories of permitted preliminary onshore works that need controlling and are not controlled?
Toby Yates, on behalf of the applicant, to confirm your summary is correct, and the applicant's position is that the only works that are listed in the permitted preliminary onshore works that should be subject to a requirement is the onshore written scheme investigation for requirement 30 for the archaeological works, and then creation of site accesses in requirement 32. And we suggest that none of the other permitted preliminary onshore works should be subject to any of the requirements, and it's not necessary for them to, because they wouldn't give rise to likely significant effects.
Got it. So can I just come to DEFA? We know what your position is, but if you summarise that for us.
Yeah, Ken Milne, representing DEFA. Just before I summarise that, I'd just like to put on record for clarification that everything said at these hearings is the DEFA position is based on previous political policies and informed by scientific research and data. They are not based on personal DEFA officer positions other than their professional capacity representing the department. So just to reiterate our position again, summarising, as per previous comments, DEFA maintain that any preliminary works that have the potential for environmental or health and safety impacts must be subject to control and consult with DEFA.
Okay, so that's understood, but just the examining body is slightly struggling with that because it feels quite broad. So are there any specific activities that you feel will have an environmental impact? And would those activities be typically controlled in a TCPA application?
Richard Armitage on behalf of DEFA. Looking through the list of what are preliminary onshore works, in the MIC, so site clearance, it would depend what that is. If there's removal of topsoil and so on, that would be controlled under TCPA. Pre-planting, landscaping works would all be covered because those are development. Ecological mitigation works probably would be as well. Intrusive environmental surveys would be. Diversion and laying of services, erection of temporary means of enclosure, creating site access, all of those would be controlled under TCPA and have the potential for environmental impact.
That roughly corresponds to the list that I had mentioned in written questions 2 as well. Department of Infrastructure, I've noted that you're generally satisfied, applicants, but just given what Mr. Armitage just said, that those matters would be potentially controlled under TCPA, is the applicant willing to consider that further controls might be required? And what I have seen, for instance, in other DCO applications is what's called a pre-construction or a pre-commencement management plan, which gets submitted in examination, gets confirmed in examination, is a certified document. It's never in our outline form. It's a confirmed document so that if you were granted consent, that document immediately has effect, no matter what pre-commencement work you decide to do.
Toby Yates on behalf of the applicant. I think it's probably worth a discussion between the applicant and DEFA just so that DEFA can better understand perhaps some detail on what precise works are envisaged by the works that are mentioned in permitted preliminary onshore works. The applicant's confident that in delivering those works, it won't give rise to any likely significant effects in environmental terms, which we understand is one of DEFA's core concerns, and therefore it's not necessary, which is the test for a requirement in NMIC, for those works to be subject to those requirements. So perhaps that's an initial starting point, is just to have more of a conversation around what those works might include. And if as a result of that conversation DEFA is still uncomfortable, then I'd have to take instructions on on whether or not an additional requirement could be captured as part of the MIC.
So just once again, because I said that I'm now starting to prepare for the examining body's commentary on the draft MIC, you've just literally said what is my next point or suggestion, which is you carry on with your discussion, but what the examining body, would you consider wording at the end of that definition of permitted preliminary onshore works, which says, provided that such operations will not give rise to any materially new or materially different environmental effects from those assessed in the environmental impact statement. Now, that is not as ironclad as a management plan, but it is something, it limits the environmental effects that could could arise from these effects to anything that's been assessed in the ES. So that's, I'm just saying that as a safety net option, while you go ahead and talk to the applicant about potentially having a pre-commencement management plan.
Yeah, just to confirm, Ken Mill representing DEFA, yeah, we'd be content with that.
Okay, so, but the conversation is what I would really prefer would take place. And so if, sorry, when are the next statements of common ground due? Are they in deadline 7?
Deadline 8.
Okay, so we definitely can't wait until then. So if we can have, if you agree to a management plan, we'd love to have that submitted by deadline 7, but give us an update at the Reg 31. Yeah. Any points from DOI?
Robert Garden on behalf of Department of Infrastructure. I think requirement 32 that has been inserted does address the comments that we had made in relation to site access and construction. We can come to it now on detailed drafting, but there was just a point that we wanted to raise around extending that to alteration of accesses as well as creation of accesses.
Raise it now.
Yes,
Yeah.
so I think the wording generally we're happy with what's been provided. It prevents site accesses coming forward without the department's approval. But as drafted, only relates to the construction of site accesses. We'd just like to make that clear that extends to alterations and alterations to the public highway, and to extend access and traffic management measures, and we can provide that wording.
Is the applicant okay to include that wording?
Toby Yates on behalf of the applicant. Again, I'll take it away and confirm in instructions in an updated MIC, but we removed alterations because I understand that alterations weren't going to be proposed as part of delivering the proposed development, and therefore it wasn't necessary to include that in the control requirement. But we'll take that away and consider, and if that's not the case, then we'll consider including alterations as part of that restriction. Okay.
Do you have a response to that, Mr. Garden, if it's not required?
Robert Garden on behalf of Department of Infrastructure. I think we're of the view it would, and that the reference to access management measures would also extend to access and traffic management measures to ensure that's in place. But we can also speak to the applicant on that point.
What I'm going to do is, what this kind of brings into focus is the next draft MIC and when that comes in. At the moment, it's deadline 7. But would it be possible to actually submit one at the Reg 31 deadline of Friday next week?
Toby Yates on behalf of the applicant. If I can suggest we perhaps revisit that as part of the discussion around what was raised yesterday as being a potential discussion point in terms of thought experiment on one hand and then also design refinements on the other, and potential for a non-material change request.
Sure, let's do that. Yeah. So is a hearing action that the draft MIC next revision would be submitted at the Reg 31 deadline of next Friday rather than deadline 7? Huh? Yeah, okay. But okay. All right. So we've covered that. Right. Then we come to the permitted preliminary onshore works. Now, that has become relatively narrow and now just relates to pre-construction surveys only. Sorry, offshore works. Yes? Applicants nodding yes. So the related provision here is requirement 25, and the control document is offshore pre-construction survey plan, and the latest version is D6-047. Now, DOI has stated at deadline 4 that it is satisfied that the definition was appropriate because it related to the... by definition, I mean the definition of permitted preliminary offshore works. So you're satisfied with that definition, but the pending matters were the wording of requirement 25, which felt were needed to be strengthening. And the main thing was that requirement 25 doesn't say anywhere that the work must be taken in accordance with the survey plan. So that's one. 2 is notification requirements, that the timing and location should be notified to DOI and DEFA before you begin with that survey. And then the third thing, and this is something that the examining body is raising, is that it doesn't mention, and I know the plan itself talks about notification, but it doesn't talk about a minimum notification period. And I appreciate that nobody lives in the ocean where you're going to do all this, see where you're going to do all this, but potentially it's valid to have a minimum notification period. So I appreciate that there's notification requirements in the plan itself, but just going by the DCO precedent on survey activity, notification, details of notification tends to be in the DCO itself. And just carrying that forward, I feel that these 3 things should be in the draft MIC in requirement 25. Yes, no, maybe?
Toby, it's on behalf of the applicant and Mr. Richter, we're happy to include that so we can take it away and consider what timing would be appropriate.
Okay. That's excellent. Notification related, that's all done. Now let's look at the offshore pre-construction survey plan itself. There's a lot of discussion that has happened yesterday at SIH 9. And we've discussed in detail about geophysical and geotechnical surveys, buffers around M&R, seismic surveys, etc. And I'm just content to rely on the outcomes of those actions. But what I want to do today is to make sure that things are not falling through the cracks between various plans. So I'm just keen to make sure that what's being controlled in different plans is collated somewhere. So let's just start from the beginning. The offshore pre-construction survey plan, to me, does not read like a control document. It just does not contain any limits. And the language is quite fluid. Techniques may include, surveys may extend across. So, you know, if you're expecting that to be a control document, then I think it just needs tightening.
Toby Yates on behalf of the applicant. That's correct that it's not intended to be a control document. This was added in throughout the examination to give some explanation as to the scope of what is intended by the permitted preliminary offshore works, given that that just makes reference to surveys and monitoring. So the intention of this requirement and the offshore pre-construction survey plan is to give some detail, additional detail to what was initially included as to what those surveys would involve.
Are you content with that, DOI and DEFA?
Robert Garden on behalf of the Department of Infrastructure. I think we just agreed that the plan will be submitted and that it will be undertaken in accordance with the plan as well as notification. So on that basis, with the additional wording that you'd suggested for requirement 25, we would be comfortable with that.
Richard Armitage, on behalf of DEFA, as per our previous submissions, we think that that plan should be approved by DOI in accordance with DEFA, and then all activities carried out in accordance with it. This is similar to DMLs across in the UK, where this plan has to be submitted to MMO for approval 6 months before the first pre-construction survey.
So just on that point, that is correct, that a lot of the survey activity very often through requirement actually through the DCOs, they tend to have a much greater detail than is currently provided either in requirement 25 or in the plan. So I think it is something that is that open for discussion, or are you putting your pens down?
Toby Yates on behalf of the applicant. So just to clarify and then to come back on your point. So we're happy to give confirmation that the offshore pre-construction survey plan will be in accordance with. So happy to make that update. We're also happy to make the update for the notification that we mentioned, but we don't intend to make it subject to approval and a control document in that way. However, we can consider the detail that's set out within the plan to see if we can expand on that.
Okay. Why are you not? Why do you not want it to be subject to approval?
Toby Yates on behalf of the applicant, because the nature of the surveys that are being carried out in accordance with that plan aren't necessary to be controlled because they're not likely to give rise to likely significant effects, which is why they were included in the scope of the permitted preliminary offshore works in the first instance.
Could you just substantiate that a little bit, maybe not right now, but in writing, and just give us that confidence that it does not give rise to anything new and additional? And likewise, if there's any justification that can come from DEFRA. And then just coming on to one of DEFRA's outstanding points, which is the relationship between requirement 19. Right, so this is, I must admit, this is something that struck me as well, that this is a survey plan. Why does it include UXO clearance? And then in that regard, what is the relationship between this and requirement 19, which is UXO clearance? Are you doing a survey of UXOs under this plan and then detonating and clearing the UXOs under requirement 19? Is there a distinction between the two things? Do you need to clarify it?
Amy Stilling on behalf of the applicant. The pre-construction survey plan was intended, as Mr Yates said, to list all of the pre-construction surveys that the applicant would be carrying out. One of those would be a survey to determine what, if any, UXO are present, and as either subsequently or as part of that campaign, the detonation, relocation or otherwise of UXO. That is also controlled by the UXO clearance requirement. So it's sort of controlled in two ways. The first is a commitment to do the survey to find out if there are any UXO there. And then the clearance of the UXO would also be controlled by requirement 19, which requires a method statement to be approved.
But I think that clarity that you've just said seems very sensible to me, but I don't think that is coming across in the wording. At least in the plan. Okay, so I think that needs to be clarified, and so I think it'll be helpful, as DEFRA suggested, that the plan actually reference requirement 19 as the next stage. Or
Amy Stelling on behalf of the applicant. Yes, we're happy to update the plan to make that clear. I think the fact it says to clear and actually what it means is to survey for.
Okay, and then just similar to this. The plan also refers to seabed preparation activities. I'm looking at parties around the table. It just once again, that does not feel like survey activity to me. So are you talking about surveys that inform later seabed preparation or seabed prep work itself?
Amy Stelling on behalf of the applicant. It's the first one. It's the surveys to inform seabed preparation activities. Again, we can make that more explicit in the drafting.
Okay. Then coming back to requirement 25, I'm sorry, I know we're moving at pace, but I hope you're just noting. So requirement 25, it talks about a relevant stage. So let's just go back to requirement 25 and it says offshore pre-construction survey plan for the relevant stage. And I did not find any reference to stage in the plan itself. So what are you talking about here?
Amy Sterling on behalf of the applicant. Requirement 4 requires the applicant to set out a written scheme setting out the stages of construction of the authorised project,
Okay.
and to have that submitted to and approved by the department prior to commencement.
Okay.
The intention was to, there may be pre-construction surveys which are within the nearshore. There may be then a different pre-construction survey which is in the offshore. The cable might be different from the array. I'm speaking in very non-technical terms. I'm sure people are cringing. But the general intention was that there may be more than one survey type for each one. Again, I think probably we could make that much clearer in the plan itself.
Perhaps by referencing a requirement 4? So if you just have an interaction between requirement 25 and requirement 4, is that satisfactory?
Robert Garden on behalf of the Department of Infrastructure, that would be satisfactory, but we had understood that to be the position, that there may be different survey campaigns for the different works that come forward as different stages. But if clarity can be provided, that's fine, but the department does understand the intention behind that wording.
Okay. Now, this next point, I know that we kind of covered that as SIH 9, and I'm going to come back to it in a later agenda item. But one of the things that I was looking for in the plan is, what will you do with the results of the survey? Should you not say something about that?
Toby Yates on behalf of the applicant. So the results of the survey is carried out in accordance with that offshore pre-construction survey plan will feed into the production of the other final plans that will be submitted pursuant to the other requirements. So that's how it's already captured as part of the requirements.
So can you just give me an example? Can you just read out a particular requirement which actually pulls that?
Toby Yates on behalf of the applicant. So the wording won't be on the requirement itself, because it will be the details within an outline plan that's then, which will be submitted for approval pursuant to another requirement. So the surveys that are carried out in the offshore pre-construction survey plan, the results of that will then help the applicant build into other final plans that are secured under other requirements, so that when those final plans are submitted for approval, the content of those final plans that are subject to approval will have been informed by those survey results. So it's the final plans that will contain the detail as to how those survey results have informed that.
Now, that sounds logical to me, but I'm looking at colleagues around the table. Do the management plans include that wording, which refers to survey findings, actually?
Amy Sterling on behalf of the applicant. I've got an example here this is from the outline biogenic and geogenic reef mitigation plan. Document, section 7.1, geophysical survey. So it says a geophysical survey as set out in the pre-construction survey plan will be carried out within the final footprint of the authorised project. This data will be subject to ecological interpretation to identify potential areas of reef and provide a conservative estimate of reef presence from which targeted ground truthing DDV surveys will be informed if required. And then it goes on to talk about what DDV is and all those other things. So the management plans refer to the surveys carried out in the survey plan, and then depending on the topic of relevance to the management plan, explain what will happen with that survey data in that context.
Would it be helpful, perhaps, for this plan to be the one place where there is that signposting of how the findings of the survey actually get taken on board in the management plans?
Amy Stelling on behalf of the applicant. Yes, no reason why we can't update the survey plan to signpost the relevant outline management plans.
Great. So let's put that down as a hearing action, but we'll just circle back to that because I do have one other agenda item where I just want to, explore something with parties, which is related to this. Okay. So that's done. Pre-construction surveys. Just drafting matters. I think the plan still refers to surveys not forming material operations. So is that meant to be there, or should that be removed given the drafting changes that you've made to the...
Toby Yates on behalf of the applicant, that can be removed. We'll make the update.
Okay, and when you're doing that, could you just check some internal cross-references? Maybe I'm not understanding it, but it seems like there's some legacy cross-references which are not working. Are you ready to move on, Mr. Yates? Okay. So agenda item C, I will come back to this if we have time. We do have quite a lot to cover. And if nothing else, I might request a hearing submission on Monday. Agenda item D, similarly, I think I have seen the cross-referencing that we asked you to do at the last round of hearings. You've been updating that in the sequence of approvals, and under this agenda item, I just wanted to go through that so that if there's anything pending, then we can address that in the commentary to the draft MIC. But I don't think we have time to do that today. So whatever you've prepared, if you can submit that as a hearing submission on this agenda item, that'd be great.
Toby Yates on behalf of the applicant. I suppose I can just confirm that D6-043, which is the latest version of that sequencing of approvals document, that sets out the applicant's final position. So you remember from deadline 4, we'd done an initial cross-referencing exercise, and then at deadline 6, we'd then gone and added further provisions into the MIC where we felt that was necessary, and also gave an explanation to where we didn't think some of the provisions from the Mona DML example that was provided. So that's the applicant's final position.
Okay. Defa, have you seen the submission?
Ken Milne representing DEFA. We've not had time to fully review all the documents that came in deadline 6. There was a substantial number of them.
Okay, so this particular one, would you please do that as soon as possible? So maybe not as a hearing submission, but for the Reg 31 deadline of Friday next week?
Certainly, we'll take that away. Thank you.
Okay. How about you, Mr. Garden? Would that be relevant?
Robert Garden on behalf of the Department of Infrastructure. We have reviewed that and undertaken a similar exercise ourselves, so we can respond to that as a hearing submission.
Okay, excellent. So that would be Monday for DOI and Friday for DEFA.
I should also say on 3C, we've prepared something on that, so we can let you have that as a hearing submission as well in relation to the articles.
Okay. Can I just remind me? Article 17 was on track. Article 21 was running late.
That's correct, and I think we expect both sets of regulations probably to be in force before decision, but potentially not close of examination.
Okay, so now both are running late then, because I thought Article 17 and 21. My understanding was that they were going to come through during the course of the examination.
Sorry, Robert Garden on behalf of the Department of Infrastructure. The regulations will be made and laid, and they won't be laid before Tynwald until October. So they'll be made and enforced, but going to Tynwald in October. But we can make that clear in the hearing submission.
Okay. So what do you propose we do, just in terms of the draft MIC? given that we need to put in a recommended MIC, are you going to propose some wording or the removal of wording that we need to put in the recommended MIC in the event that this comes forward before the Council of Ministers make a decision?
Toby Yates, on behalf of the applicant, no, we suggest that the MIC is kept as it's currently drafted.
Okay.
The reason for that is that there's then nothing stopping the Council of Ministers in granting the MIC from removing those provisions from the MIC if at that point the provisions that Mr Garden's referred to are in force. And that way the made order would not include our provisions and the provisions of the new legislation would apply.
Okay.
Equally, we've heard the suggestion from the DOI around including some wording that says if in future some regulations come in force, they would replace the provisions in the MIC. The applicant's position is that that's not necessary, and it'd be more appropriate for the incoming provisions to include wording that would say, for the avoidance of any doubt, that any provisions in the MIC, if the order had been made, would no longer apply. And the reason for that is because the applicant hasn't seen the full extent of the new regulations,
right,
and therefore can't say that those new regulations should apply over and above the MIC.
Got it.
Whereas the department has obviously seen the MIC, so can take a view in making the new legislations that that is the appropriate replacement.
Understood. Okay. Are you content with that?
Robert Garden, on behalf of the Department of Infrastructure, yes, we are. So we suggested some wording, and we can agree that.
Wording for what, though?
For what happens if the regulations were to come in effect after
okay.
The MIC takes effect.
Okay. Yeah. So then that does not have any implication on the examining body's commentary to the draft MIC, I believe. But anyway, just make sure you have. If you could please just have that with us for the Rec 31 deadline for Friday. Just for the members of the public, we are talking about a recommended MIC, and I just want to clarify that whether or not the examining body recommends the application is granted consent or that consent is withheld, the examining body has to prepare for the Council of Ministers going against its recommendation. And so it needs to put forward a recommended marine infrastructure consent in either scenario. So the reason I'm talking about a recommended MIC, which for some of you might feel confusing, is just for that purpose. It does not mean any predetermination. All it means is that whether we recommend approval or we recommend that consent is withheld, we have to put forward a recommended marine infrastructure consent. Okay? All right. We'll move on. We've done D, 3D. Now with 3E, I think we covered this in great amount of detail at SIH 8. We've got some draft MIC related action as well, so I'm not going to cover that. Right, now when we were talking about the survey plans, I said we're going to come back to this briefly. The environmental management plans. Now, of course, we've had quite a lot of discussion at SIH and at SIH 8 and SIH 9, and the management plans are becoming quite bespoke and topic specific, and that's absolutely fine. But we have been exploring if there's an opportunity to pull out some of the common themes that are running through these discussions. So you will carry out further surveys. Those surveys will results will inform detailed design. You will then identify and implement any necessary mitigation, and then you'll change the approach if necessary through adaptive management. So there are some common themes that are running across. Then and that might be entirely appropriate, but the examining body did want to explore, once again, because, the management plans have come in during the course of the examination, have been, revised at pace, whether there is benefit in actually pulling out some of those consistencies and, putting an overarching provision in the draft MIC. And it would potentially act a little bit like a safety net for some of these things that, parties and the examining body will feel that when it comes to implementing the proposed development, should it be given consent, will be quite helpful. So any comments from the applicant on that? Have you seen precedents?
Toby Yates on behalf of the applicant. We'd be interested to see some form of drafting that the examining body would be interested to see in marine infrastructure consent, because we're not aware of any and conscious we'd want to be helpful, although the applicant's initial position is that we wouldn't necessarily see how that could work, given there's different triggers and they apply in relation to different areas of the development, and therefore we consider they best sit in those specific management plans. But we'd obviously welcome any proposed drafting for review if that's something the examining body is interested in.
Yeah, you're the lawyer, Mr. Yates. So we were going to ask you to provide without prejudice wording to us for something like this.
Toby Yates on behalf of the applicant. We're happy to take it away. I suppose it's difficult, given the applicant's position, is that it's not necessarily in the wording we've put forward is the wording that we consider appropriate. So we can obviously look for precedent to see if it's been done before, and if not, consider how that may be appropriate. But the applicant's position is that we're comfortable with how it's currently structured. Okay, so what I'm going to suggest is you take this away, think about it, and we are making this suggestion without prejudice ourselves, because at the end, we're also, working out how these, these plans in quite a bespoke way. So if I could suggest that you propose some, did you want to come in? If I could suggest that you come in with some form of wording for the Reg 31 deadline next Friday, and if we then use that, and if you're not satisfied or satisfied, whatever, we can then suggest something in the examining body's commentary. Toby Yates on behalf of the applicant, we can definitely take that away. I suppose just to add as well, obviously from the legal perspective, I'd be conscious as to how enforceable a new requirement could be if it overlaps with other existing requirements. So I suppose what we can consider is potentially an alternative to a without prejudice requirement, and potentially an illustrative document that might just set out where those different commitments that have consistency are secured. So we're not actually altering the legal framework and the commitments under those, but we can at least identify the consistency that you're after.
Yeah, I think that's that's absolutely. So take that away, mull it over and see what the best way forward is.
And so a couple of thoughts strike us in response to this conversation. At the beginning of the examination, we asked you to put together a plan of plans which set out the relationship of the different control management documents to each other. And actually, we probably do need to update that, so we would ask you to do that in any event. But it might be, and again for consideration, that the beginning of that document looks to address some of the questions that Ms. Sahai has just raised about the commonality of approach to the control documents and the management plans. Maybe that's the home for it. But I say that with the idea that maybe just take it away and have a think about it.
That's noted, thank you.
Sorry, just to be specific, there is an action that says, please can you update the plan of plans? And actually that segues quite nicely into the next item on the agenda, item G, in relation to the landscape enhancement plan. I'm not planning to discuss this in any great detail, other than to say, following the discussions earlier in the week, we will be looking for a new requirement on the landscape enhancement management plan. And I'm assuming that you're nodding in agreement.
To be it's on behalf of the applicant, yes, we took the action to prepare without prejudice draft requirement.
Okay, I think we can move on to the next agenda item. Sorry. And so this agenda item is 3H, and it's for comments from DEFRA. And I know that there's a few matters that got aired yesterday with respect to your concerns, pending comments on draft MIC, a lot of them to do with you requiring to be consulted, for instance, with respect to the decommissioning plan, I believe, and there's a couple more. If there are any other matters that are not covered and that are unlikely to get resolved, it would be really good to hear them now.
Ken Milne, representing DEFRA. No, I don't believe there's anything else we wish to raise. Yeah.
Okay. Is that okay with the applicant on their pending?
So be it's on behalf of the applicants. Yeah, that's fine.
That's fine. Okay. And then comments from DOI. There's one that I do want to raise, and that is requirement 27. And so I'm assuming that is still a pending concern. And it is basically, I believe your concern is that that requirement 27 contains some but not all of the key parameters assessed in the ES. And it identifies maximum access road and OECC corridor parameters that should also be secured.
Robert Garden on behalf of the Department of Infrastructure. I think the parameters that have now been secured secure the key parameters. There's a new access parameter that was added at deadline 6 to address that comment. So that was added in the most recent version of the draft MIC that the applicant has submitted.
Oh, my apologies. I'm looking at the clean version of the draft MIC actually. So is that in
Yeah,
requirement 27?
It's included as Lim D in requirement 27 now as a track change in relation to that point.
So I don't actually see Lim D. You do?
4.
Oh, 4, sorry.
4.
Yeah.
Okay. Yes, I see it. Okay. Understood. Okay. No action. And then we had one question, which is that you've added the 13,000 meter square limit for temporary landfall construction compound. Can you just explain what that means? Is that for each site? Is that can that even be? Will that fit in that triangular site in Groudle Bay?
Dr. Carroll, on behalf of the applicant, in relation to Groudle Field, if you remember from the plan that was submitted, I think it was HS 3008, it showed the outer perimeter of blue area, that is the 13,000 metres. It would be less than that. That area isn't available within the beach, and as per the EIS, a maximum design scenario, so not in all cases will we need that. But that's how it's demonstrated on the plan.
And what about the beach?
I just said it's not available on the beach, so it's less than that.
I see. I'm with you. Sorry. Okay. Oh, that's fine. Okay. Is DOI content with that?
Robert Garden on behalf of the Department of Infrastructure. Yes, we're content with that, given that these are maximum parameters.
Understood. Okay. Fine. Okay. I will now move on to agenda item 3J. Are parties content to come online? Burgess Salmon on behalf of Mona Offshore Wind Limited, Flotation Energy, because I think a lot of the pending concerns here are relating to wake effects, and basically an update on discussions regarding commercial agreements to address wake effects, and a submission on whether draft MIC should include a requirement. So I'm aware that a lot of parties have submitted wording for that requirement.
Amy Sterling on behalf of the applicant. If I may, Madam, I
Yeah.
can, in just a very short summary of the
Sure.
applicant's position on this before we go to all of the different parties. The applicant's firm position is that there is no justification in law or policy for a wake effects requirement or indeed for protective provisions, and the applicant does not propose to include a wake effects requirement or protective provisions within its draft MIC. The applicant set out through multiple submissions to date, and just as sort of advance notice, we're planning to pull those all together into a wake effects position paper for deadline 7, because the nature of the questioning and the response means sometimes the positions split across 4 or 5 documents.
Yes.
So we thought that and aviation actually are 2 topics we thought would be useful to pull into position papers for deadline 7. The applicant considers no requirement is necessary because it has complied quite clearly with in its view, with the MPS policy in this regard. It's carried out a wake effects assessment prior to the examination of this application beginning. It has sought to mitigate those effects, and it has collaborated in its view with the developers to the necessary extent. The applicant is progressing 1 commercial agreement outside of this planning process with Walney Extension, which was previously flagged at the hearing. Those discussions are going well. The applicant is not progressing or proposing to progress any commercial agreement with any other party. And in any case, the applicant considers that commercial agreement to sit outside of the planning process, noting that the supplementary guidance on wake effects from the UK government, which we've all agreed is capable of being relevant and important, considers that also to be appropriate. So that's, in summary, our position across all of the parties who are sort of represented today.
Yeah, Ms. Sterling, you've given us that summary before, but it is helpful to be reminded of it. Just remind me, the 1 commercial agreement with Walney Extension, is that on account of your findings in terms of the wake effects on Walney Extension?
Amy Sterling on behalf of the applicant. It does relate to the wake effects. It's not necessarily an indication that we consider it to be significant, but we do appreciate there is a reduction in AAP for Walney Extension, which we've taken the commercial view, so should be subject to some form of commercial resolution.
Okay. Do you want to come in?
Thank you very much again for summarising your latest position there. That's appreciated. In timing terms, I think this kind of aggregate position paper on wake effects, is there any possibility of bringing that in at the Regulation 31 point as opposed to the Deadline 7 point? I make that simply because what that will enable us to provide for, and I'm anticipating what I suspect may come from parties online, is that we can then expect parties online, if they have any residual concern in respect of it, to make those as proper written submissions at Deadline 7, which in turn does provide the applicant with the ability to provide a concluded position in the nature of almost a closing submission on this point in good time before the closure of the examination. So that feels like it's a sensible process, but it does require a little bit of front loading.
Amy Sterling on behalf of the applicant. Yes, we're happy to take that position, the action for the wake effects position paper. I also mentioned an aviation position paper. I would suggest that Deadline 7 is a more appropriate deadline for that, because as we'll get to, as I'm sure when Ms Grange has an opportunity to speak perhaps in the next agenda item, the aviation discussions are still ongoing, and progress, I think, is being made or at least expected on agreed drafting of requirements, etc., before Deadline 7. So I think the procedural deadline might preempt early those discussions.
Okay, noted. And will allow Musgrange to speak for herself, no doubt, when we get to that point around essentially where that lands in terms of bringing a concluded position in before the end of examination. But I think for the action on this point, are we clear then that we're having this in at the Regulation 31 point with an opportunity to respond for the other interested parties on this point at deadline 7?
Yes, sir.
Okay. And then just one final check-in. I mean, your position on the nature of the commercial agreement that you're progressing is clear and noted. It may be a trite observation, but simply that if there were anything that any party to that agreement is seeking us to consider and accord weight to, even though we would not normally see that agreement because it would be commercially confidential, then a document that records in agreement between yourself and the relevant party or parties that it has been concluded and that it provides for things that are measurable in policy terms that can be accorded weight is something that would be useful before the end of the examination. However, that is only necessary if it ends up containing something that in either your or their submission is still policy relevant and requires to be accorded weight. So can I ask for your in-principle view on that, and then the other relevant party can respond when we get to them in a few seconds.
Amy Sterling, on behalf of the applicant. Yes, my instructions as of this morning were that the discussions between the applicant and Walney Extension were progressing well, and that the applicant was confident of an agreement to be reached before the end of examination. I would need to take instructions on exactly what, if anything, we could disclose at that point on the nature of the agreement being reached or and the content of it. But the point is understood, sir, and if the timescales should allow for it.
Excellent.
Can I just invite the 4 parties that are attending for this agenda item, Mr. Munro, Mr. Gardner, Mr. Gregg and Mr. McNamee? Mr. Munro, you're on my screen now. Would you like to add anything to the agenda item? Then Mr. Gregg, then Mr. Gardner, and then Mr. McNamee.
Yes, of course, Madam. Patrick Munro for Mona Offshore Wind Limited. Mona set out its overall position on wake effects within Section 3 of its Deadline 5 submission, which is document reference D5-048. I'm not going to rehearse that in any detail, but it set out effectively that there was a disagreement with the applicant on whether it had complied with the relevant NPS policy. In particular, Mona does not accept that the relevant policy on engagement and collaboration has been met, and it doesn't consider that the applicant has demonstrated that it has carried out relevant mitigation for wake effects. As a result of that, Mona's position remains that a requirement should be included within the marine infrastructure consent should consent be granted, and Mona has put forward draft wording within that submission. One point just to make on the requirement, there's been a few references to commercial agreements, and that was noted in the agenda. The requirement that's been put forward by Mona doesn't require a commercial agreement to be entered into. What it does require is either the applicant to demonstrate that it has agreed a form of wake effects mitigation with the owners of the relevant wind farms, or to submit a wake effects plan for approval of the Department of Infrastructure. And that plan would need to set out any reasonable steps that the undertaker proposes to minimise wake effects. So that it's not a requirement to enter a commercial arrangement, although that might be one way in which it was addressed. It does provide another mechanism to get approval of the Department of Infrastructure, which effectively is to remedy what Mona's position is, that there has been non-compliance with policy. That would allow it to be effectively remedied through the discharge of that plan.
Mr. Munro, I'm slightly confused that if it is just about collaboration, then how, if you are going to meet all the tests of that requirement, or for instance, if the undertaker was to mitigate any effects, how would those be measured in order to make this requirement reasonable and, you know, all the things that it needs to be?
So the Patrick Monroe for Mona Offshore Wind Limited. So it's not simply about having not engaged with Mona Offshore Wind Limited. It is also about a failure to have demonstrated that mitigation has been undertaken specifically for wake effects.
Mm-hmm.
And so within the draft requirement that has been put forward, if a wake effects plan was to be submitted, it requires an assessment of the impact on annual energy production of the relevant offshore wind farms.
Mm-hmm.
It then needs to set out details of steps that have been taken by the undertaker to minimise those wake effects
Mm-hmm.
on the relevant offshore wind farms. And there's a limb within it that sets out that the undertaker is not expected to materially reduce the capacity of the authorised project. It also requires timescales for implementation of any mitigation measures put forward, any time limits on which that will be undertaken, and to set out the details of any further consultation that there has been with the affected parties on those mitigation measures. So it's a package of of proposals put forward to the department.
Okay, that's understood, Mr. Monroe. And yes, your deadline 5 paper, I have seen that, but the applicant obviously has put forward its position where it suggests that it has met those policy requirements. So we have both those arguments before us, so I'm not actually asking for anything further at this point, except for the action that Mr. Smith has already set out. I'm going to hear from all the parties before I come back to you. Sorry, I can't remember who's next. Mr. Gregg?
Yes, thanks, ma'am. Michael Gregg, DLA Piper for Wolney Extension Limited, Wolney UK Offshore Wind Farms Limited, and Ørsted Schroders Greencoat Woods Holdco Limited. Largely agree with what Mr. Monroe has said in relation to the applicant's non-compliance with NPS policy. Mrs. Ma'am, I represent a variety of existing offshore operators, and the position is slightly different in relation to Wolney Extension, as you've noted. There are discussions in relation to a commercial agreement, which are now progressing. I think the difference, though, between the applicant's position and Wolney Extension's position in this is that in the event that commercial agreement is not concluded by the end of the examination, then our position would be similar to the other offshore wind farm operators, including Wolney 1 and 2 and WADS, that a requirement should be imposed to require mitigation. And again, as Mr. Monroe has said, I think we've both used the same sort of model of suggested requirement and wake loss.
Mm-hmm.
There's a mechanism in there to allow for wake loss to be addressed by means of a commercial agreement. So essentially, in the event that by the end of the examination we haven't quite got there, then there's still a mechanism there to ensure that wake loss is addressed for Wolney Extension.
Mm-hmm.
Whether that's by means of continuation of the discussions on commercial arrangements or otherwise. Other than that, there was a couple of other points that I just wanted to add to our submissions. In common with Mr. Monroe, we've made quite extensive submissions on wake loss, and again, I don't want to go through those in any detail just now. What I would just want to pick up on, though, and again, I alluded to this earlier on at the start of the session, is the applicant's new indicative without prejudice layout, and it's a couple of points on that, ma'am. Firstly, this is not a layout that's been discussed with any of the existing operators, as far as I'm aware. Which again kind of reiterates the point that there's been a lack of engagement by the applicant through the whole process. It's appreciated that, again, there's a slight distinction here with the position of Walney Extension, where there are ongoing discussions in relation to commercial arrangements. But other than that, in relation to my other clients, there really has been no engagement from the applicant other than at the very start of this examination process. There has been information which has been promised to them in relation to the differences in weight loss assessments, but that has not been forthcoming, and there really has been no further engagement at all. And again, that's reiterated again that this layout has come into the examination without any discussion with wind farm operators, notwithstanding that the document that's document D6006 looks at potential environmental impacts and comments on the position with existing wind farms. I think the point, ma'am, is that there's a potential different layout here, different to what was considered through the weight loss assessment earlier in the examination, and there's no updated weight loss assessment to demonstrate what the impact of this amended alignment might be. So it illustrates, one, the lack of engagement, two, a lack of assessment of wind effects properly. But thirdly, I think what's interesting about it is it also illustrates that there are further amendments that can potentially be made to the proposed layout, which of course is the point which we are making, and others acting for existing operators also making, that there is potentially scope for more that the applicant can do, which underlines the point which we've made, that there is insufficient evidence that the applicant has taken effective measures to minimise wake effect. So I think, ma'am, that would probably be my submission for the current time.
Thank you, Mr. Gregg. Now, the submission in broad, I guess, philosophical terms that's been placed in front of us, if I can summarise it, by the applicant, is that the thought experiment does not give rise, in their view, to any materially different stroke materially more adverse effects than those assessed. And so the proposition, therefore, ought to be that if that holds true in this setting, in relation to these very specific stakeholders, that nothing that has been proposed in the thought experiment ought to lead to a prospect of materially additional adverse wake effects. Ms. Sterling, without prejudice to detail, because there's an evaluation against all of the heads of the EIS that is going to be required to be carried out on the thought experiment. But with that in mind, with these stakeholders in the room, is that, in your view, broadly true? And what additional, if any, documentation might be required to set out an evidence base for that?
Amy Sterling, on behalf of the applicant, yes, my understanding is that is broadly true, because in our previous submissions, you'll recall, sir, that we confirmed, I think in response particularly to Morecambe, who have raised this point, that there is no reasonable configuration of the maximum design scenario, which would mean that the wake effects which were assessed in the wake effects assessments submitted pre-examination could materially change. And given the thought experiment represents a quite substantial reduction in the maximum design scenario, then that logic would mean that it would hold true. I don't have information in front of me about what the specific implications would be for the wake loss assessment on the indicative alternative layout, so I can't answer your question specifically, other than to repeat the statements we previously made about the role of the maximum design scenario, which is the point I think you were making, sir. Whilst I do have the the opportunity, I do think it's useful to just respond to a couple of those points about the role of the without prejudice indicative alternative layout. Firstly, I would flag that this was first submitted into examination at deadline 5, of course available in the examination library for all parties to view. I would reject this suggestion that the MPS requirement to collaborate requires the parties to reach out every time it puts together a submission that may have some impact. That is submitted into examination, and Mr. Gregg and others have an opportunity, and I've had an opportunity to comment on it if they so wished. I would also suggest that it doesn't depict a scenario where the applicant has failed to mitigate, and this demonstrates actually there is a reduction in the scheme. As we've discussed quite extensively this week, the indicative alternative layout represents an approximately 21% reduction in generating capacity for the project.
I think we're very clear about the kind of macro.
Yeah, I think Mr. Gregg was suggesting that this demonstrates that there's a mitigation solution for wake that we haven't previously put forward. I would suggest that the policy is very clear. It says, in practice, this means developers do not have to take every possible course of action to mitigate the wake, and that only reasonable endeavours and reasonable efforts at mitigation are required. And I would suggest that a 21% reduction in generating capacity is not reasonable in the context of the wake effects discussions that we're having. So I just wanted to make clear that we reject that suggestion.
Okay. However, there is an at least unexcluded theoretical potential for a substantial order array reduction in certain circumstances, depending on the siting of specific wind turbine generators, to maybe not, possibly not, have the end state effect on recipients of wake effects that might be proportionally beneficial in the same percentage terms as the other reductions, if that makes sense. I know it's quite complicated.
Amy Stilling on behalf of the applicant. I'm being advised in the room that we could, if helpful, the examining body seek to update the wake effect, well, not update, provide without prejudice wake effects assessments which demonstrate what the wake effect would be from the without prejudice indicative alternative layout on the schemes that have previously been identified. The caveat is I've told we don't know exactly when we could do that, so perhaps as a hearing submission we can confirm when we've spoken to the wake effects providers or modelers, I don't know what particularly we call them, what those timescales would be.
Okay, so if we're thinking of doing that, and I do think in the circumstances, given the nature of the oral submissions online that have been made this morning, there would be considerable virtue in that, and I see nods from my colleagues. What we need to be mindful of, and what we would be looking from you to provide at Reg 31 point, is essentially then a kind of mini timetable breakdown, so that we are clear that we don't get this at deadline 9, for example, when no other parties, principal stakeholders who might have an interest in this point, have any measure or capability to respond. It needs to be at a point in examination, in principle, for natural justice reasons, early enough to enable them to respond, and actually for practical purposes, given your wish to make your final points to us at deadline 9, early enough for you to make your points to us at deadline 9, based on what they have said. So realistically, it's got to be in at deadline. They have got to respond at deadline 8, so you've got to put something out probably at deadline 7.
Amy Sterling on behalf of the applicant. My colleague is frantically working in the background, is advising deadline 7 should be achievable. We'll confirm in writing next week.
Okay. Are we content that's an action?
I'm very mindful that we've not heard from Mr. Gardner and Mr. McNamee. Mr. Gardner, you
Oliver
first.
Gardner
Thank you.
Oliver Gardner on behalf of Morecambe Offshore Wind Farm Limited. Just to say, I don't really have much to add to the points made by Mr. Monroe and Mr. Gregg. Our deadline 5 submission made very similar points, and just to reiterate the points that they both made, particularly the points around Mr. Gregg around the timings of this, and the fact that the wake effects requirement doesn't actually require a commercial agreement. It's just a process that will be followed in order for the applicant to demonstrate that they've taken into account the wake effects and consulted with the other parties. So nothing further to add at this stage.
Thank you, Mr. Gardner. That's actually quite a helpful summary. Mr. McNamee.
Mr. McNamee for Scots for Renewables in respect of West of Duddon Sands. I'll be brief as well. I fully support the comments made by Mr. Gregg, Monroe and Gardner. I would also make the observation that for the full benefits of this project to be felt by the Isle of Man, we will also need a transmission assets development consent order approved by the Secretary of State in England. Now, that process won't have the opportunity to correct any defects in a marine infrastructure consent. And I would suggest that while the applicants may not be willing to engage in these discussions, it's to the benefit of the ministers and the Isle of Man that this marine infrastructure consent does contain a wake requirement, and would be happy to work on a without prejudice basis with the applicants to draft one to assist the examining body when making their recommendation.
Ms. Sterling.
Amy Sterling on behalf of the applicant. I'm not sure I fully understood the relevance of the East Irish Sea Transmission Project DCO to whether a wake effects requirement is included within the draft MIC. I noted that Mr. McNamee was suggesting that he would work with us to put forward a without prejudice wake effects requirement, or a form of wake effects requirement. My current instructions are that we are not proposing to put forward a with wake effects requirement, without prejudice or otherwise, noting other parties are of course free to put forward their own drafting. I will take that away and consider with my client.
Mr. McNamee, I think Ms. Sterling, and partly I also have the same question. Just explain to me the relevance of wake effects to the East Irish Sea Transmission Project. Why would that make it more compelling to have a wake effects assessment and requirement?
So there are two underlying reasons for this. One is obviously that all other offshore wind farms seeking to supply power to the UK market would have to come in line with Secretary of State policy. The second is that any future transmission assets application, there is a good possibility that the Secretary of State would request a whole project assessment of some form be undertaken. And at that point, it would become clear that his own policies relating to wake effects hadn't been complied with. So my suggestion is that having a requirement imposed now would actually help the applicants later.
Mr. McNamee, the second point is understood. Could you just repeat the first point? My apologies.
Yes, sorry. The first point is that all other offshore wind farms seeking to supply power to the English market
Got it. Yeah.
do have to comply with NPSs, so it would be unusual for the Secretary of State to effectively allow an outlier project which didn't comply with his own policies.
Thank you, Mr. McNamee. I am keen to close this down. We've heard from all the parties. I think that is an interesting point, though, and if you can take that away in whatever paper that you provide. Okay, Ms. Sterling, yeah.
Amy Sterling on behalf of the applicant. Just to have one important clarification. We, of course, agree that the application for the East Irish Sea Transmission would be determined in accordance with the national policy statements. There is no suggestion in national policy statement that a wake effects requirement must always be imposed for an offshore wind farm, as appears to be the suggestion. And in fact, there are recent examples where no wake effects requirement has been imposed and also being found to be in accordance with national policy, so we would reject that sort of implication. I would also make the point that this application is being considered in as far as we have an examination to date as if the MPSs are important and relevant considerations. So that wake effects policy within the MPS is being considered in the context of this application. So it's not the case, as perhaps was being suggested, that it was sort of being ignored or not given any credence.
Okay. Thank you. That's helpful. I'm going to draw this to a close now, but I think we've got an action from Mr. Smith on this point, and 4 parties, and an action from. Sorry, no, the action from you was to the applicant, wasn't it?
It was, and essentially there, in a nutshell, that at the Reg 31 point, they must set a mini timetable breakdown to demonstrate how
Yeah.
they will A, document the potential effects in terms of wake effects of the thought experiment, and then B, provide a bounce down that ensures that parties with an interest in that dialogue are able to use remaining deadlines in the examination to make due written comment on it, and bluntly, that the applicant themselves then ought to be able to put a concluded position to us.
Thank you very much. Oh, sorry. Mr. Garden.
So, Robert Garden on behalf of the Department of Infrastructure. Conscious this is the last hearing that we've got scheduled on the draft MIC. Just 2 points that I would make, and without recognising the various parties' position, that some parties think a requirement's necessary, others don't. But in terms of this item, it doesn't sit alone. So any changes that you might be minded to make or in a recommended form, I think the design and layout plan would need to reflect those. And I think it's also a point worth noting that the department doesn't have an expert on weight loss, and I think probably reasonably wouldn't be expected to. So there may need to be provision for an independent third party to assist with the department in any requirement should you feel it necessary to impose it.
So in that regard, what I would request you, Mr. Garden, is to look at the requirement drafting that has been provided by the parties that were on the screen at the moment, and suggest your own drafting to include the independent third party, but equally also suggest what we need in the design and layout plan to change. Yeah. Okay. So given that all those submissions are already in, if we could have that at the Reg 31 point. I'm very conscious that a lot of the actions at SIH 10 are Reg 31, but simply because it gives me the time to then take into account for the commentary on the draft MIC. Okay, we do have several parties joining for agenda item 3K. But if you please bear with us, we will take a break now. And I'm going to request parties to come back at 5 minutes past 12. And we will carry on with agenda item 3K, which I really hope to finish in 20 minutes and then move on to session 2. Yep, thank you. Okay, the time now is 5 minutes past 12, and we'll start with session 2 of SIH 10. I'm going to resume agenda item 3K. And this was a bit of a catch-all, other matters, because we were just very aware that we were sending the agenda out before the D6 update to the draft marine infrastructure consent. Oh, my apologies. My apologies. Is that better? Yeah? Okay. Great. So we'll start with microsighting and the newly introduced macrosighting. And at SIH 8, the applicant explained that microsighting allows movement of foundation within 50 meters. Macrosighting will allow movement of up to 150 meters. And if I'm not mistaken, macrosighting only refers to the export cable. Am I correct in all of my understanding?
Dr. Carroll, on behalf of the applicant, just to clarify, the 50 meters microsighting, so the term microsighting and macrosighting I might have confused slightly, so I'll provide exact clarification now. Microsighting is the term used to the placement of infrastructure during the construction phase, and for foundations in the array, that is limited to 50 meters.
Okay.
For the export cable in relation to the island link, that is limited to 150 meters. The term macro sighting, I mistakenly referred to as the 150 meters. Macro sighting is the pre-construction surveys, so the geophysical, benthic surveys, all of that is brought together. Then the initial cable installation is plotted relative to that. That's agreed with DEFA. So the installation of the buffers relative to the sensitive features, and then the removement of the cable, that's the macro sighting part that occurs. So that's macro sighting. And then once the cable is being built, then we can deploy the micro sighting should some engineering constraint become available during the installation that wasn't previously identified.
Okay. So the actual numbers is not necessarily the distinction between the two construction. One is a construction-related activity, the other is a survey-related activity, so the numbers have nothing to do with them.
Micro-sighting has specific numbers, 50 meters for the foundations, 150 meters for the exports for the island link. Macro-sighting is just a pre-construction approval process with DEFA.
Okay. Really. I'm going to invite MCA, the Marine Conservation, because... Sorry? Yeah, of course.
Forgive me if I am being slightly not quick on the uptake. So they're both microsighting, except that microsighting is 50 meters in respect to the foundations for the individual wind turbine, and microsighting is 150 meters for the island link or the export cable. Yeah, I've got it. Thank you.
Okay, so I have a few questions about that and whether in relation to the draft MIC, but perhaps inviting the Maritime and Coast Guard Agency, Mr. Salter. So if you want to just provide your comments on this point.
Right, thank you, ma'am. So what you've just been discussing and clarifying is not my understanding as per the layout principles, which confirm that the turbines can be increased to 150 meters.
Dr. Carroll, on behalf of the applicant, that was in a previous version that has now been updated to 50 meters for offshore infrastructure. So in relation to turbines, the layout principles confirm that 50 meters is the tolerance for microsighting. The 150 meter was an error on our part. We applied it across all microsighting, and then it's subsequently been updated at deadline 6 to differentiate between foundations up to 50 meters and for the cable, the export cable associated with the island link, and only the island link, for up to 150 metres.
Does that clarify? So, sorry, actually, Mr. Salter, before I come to you, when you say that that has been updated, where has it been updated? Is it just in the design and layout plan, or is it mentioned? Because I've looked for it in the draft MIC and I cannot find any reference to macro siting there. Is that something that needs to be defined in the draft MIC?
Toby Yates on behalf of the applicant. So the provisions that Dr. Carolan's referring to, the 50-metre provision, is in the outline design and layout plan, which is D6-051, and that plan is already secured by way of requirement. And then the previous wording that you'll see from the track change version of that document that refers to the 150 metres, that has now been captured as part of the cable specification and installation plan, which is D6-059, which is then also secured by way of separate requirement.
But what about the concept of macro siting? Is that something you need to secure somewhere, perhaps in the pre-construction survey plan?
Amy Sterling on behalf of the applicant. There's also sections which have been added into the relevant management plans where macro siting is referenced. And for example, I'm looking at section 8.2 of the outline biogenic and geogenic reef mitigation plan, most recently updated at deadline 6. And section 8.2 has a section macro siting versus micro siting and sets out an explanation of the differences, which can then track through how they're used within that control document.
Okay, and I'm just wondering, given the action that you've taken away with respect to the pre-construction survey plan, is that another place where this perhaps needs to be clarified?
Amy Sterling on behalf of the applicant. We're undertaking and updating that plan to refer to where the pre-construction surveys feed into the outline plan. So as part of that process, we'll consider whether or not the macro-micro siting distinction is relevant to flag there too.
Okay. Mr. Salter, do you have any residual concerns?
Nick Salter for the MCA. No, thank you. I've just checked that the updated layout principles from deadline 6 and within Annex A, I can see it's been updated, so we are content with that micrositing issue. Thank you.
Thank you. And while you're here, did you want to talk about your concerns with requirement 24? 20, yes. Paragraph 4.
Yes, thank you. Requirement 20.4 refers to the ERCOP, and we've been very clear that we the MCA do not want the ERCOP to be published once it's been agreed. So we sought clarification on whether the DOI would publish post-consent documents, but we haven't had a response on that one. However, requirement 21.1 covers MCA requirements, so I propose that requirement 20.4 is removed.
Is there I mean, you've previously submitted orally to us on your view that the ERCOP should not be a published document, and so we've heard and noted that. In terms of the mechanism whereby that might be given effect to, how can we best secure that? Now, I had thought about a model in which it is submitted to and approved in respect of UK waters by yourselves, and then in respect of other man waters by DOI, and so there are it then becomes two separate things. You then essentially may do with it as you see fit, or do we need some words on the face of paragraph 4 to achieve the end that it and it shall not form a published document?
Amy Sterling on behalf of the applicant. If I can just make a point here that the applicant has already updated the outline emergency response cooperation plan to add paragraph 5.115. That paragraph reads, the final version of the RCOP to be approved pursuant to requirement 24 is to be treated as confidential. Disclosure will be limited to the applicant, the DOI as discharging authority, and the MCA as the named consultee.
I've noted that, but the trouble with that is it's in a daughter document, so to speak. It's not on the face of the order. And so there is a counter proposition, which is that the normal procedure for a certified document would apply, notwithstanding what it says in itself, because it has no power to say that for itself. The power rests in the order. That's a possible approach. Is that something that you...
Amy Stilling on behalf of the applicant. I take your point. I don't think this has ever been a point that we've been particularly pushing either way. I guess if the MCA wants it to be confidential, we've already committed to that in our plan. I would, the DOI are the discharging authority and responsible for managing. I'd be interested in.
I observe all of those things, but I guess the point is, if there is a justification for its confidentiality and it's going to be confidential, then the last thing you want to do is to say it's going to be confidential and then find you have no legal power. There are no varies to actually make it confidential. I think we should probably go to DOI themselves on this, and also then finally hear from MCA on it before we land the point.
Yeah, Robert Garden on behalf of the Department of Infrastructure. I think for the reasons you've just identified, if this is to be a confidential document, we would want probably not a requirement, probably an article on the face of the MIC that expresses that clearly, so that it is made confidential.
Amy Stilling on behalf of the applicant. I see no reason. I'll need to take instructions, but I see no reason why not. Mr. Salter, does that satisfy you? But Mr. Garden, I think there was the other point about consultation, whether or approving authority, or discharging authority, whether that becomes MCA rather than DOI.
I think in terms where we've got a very clear head of power for the proposition that this is a confidential document, then that point kind of evaporates. I was looking merely for mechanisms that would enable the management of the document in an appropriate place. But if it's clearly confidential everywhere, then I'm not going to press that point.
Robert Garden on behalf of the Department of Infrastructure. I agree. I think as long as we have that article on the face of the MIC, then we're happy to remain as the discharging authority.
Okay. Mr. Salter, are you satisfied with that?
Nick Salter from the MCA. Yes, that would be a satisfactory solution. I think we can save ourselves the work and simply remove requirement 20.4, which will save everyone a bit of work, and we'll rely on 21.1, which is how it's managed in England and Wales. So I'm happy either way, but what I'm saying is that you can save yourself a bit of work by introducing a new article simply by removing the layout requirement. Sorry, the RCOP requirement condition.
At risk of prolonging this, the effect though of, and this may be a point for England and Wales, is that if you actually remove the order provision for an RCOP, again, proposition, it has no varies. It cannot be implemented.
Nick Soul from the MCI. I disagree, because we can pick it up through condition 21.1, where we will ensure that an RCOP is provided.
I think what we've got is quite a good situation. It's a good problem to have, is that we have a few solutions. And so all I would say is that this probably requires a three-way telephone call between the three parties to just agree a way forward. In my mind, what Mr. Smith has suggested in terms of, or actually what the applicant suggested, Mr. Garden suggested having another article on the face of it about keeping confidential seems to be the most watertight one, but ultimately I think it's about satisfying all parties. So if I can just leave that with parties. Once again, because this is to do with draft MIC drafting, if I could have this by the Reg 31 deadline of Friday, an agreed position, that would be very helpful. Mr. Salter, I don't believe you have any other points, but if you do, now is the time.
No, thank you. It was just those 2 points.
Okay, thank you. All right. The next, I am going to just invite BAE Systems for requirement 15. I believe there are just a few matters that are still pending. I've got Miss Grange.
Yes, ma'am. Samantha Grange for BAE Systems Operations Limited. If I can just pick up on the question about the appropriate deadline for submitting sort of a further update or aviation related position statements, which Ms Sterling has already sort of touched on. I think we do agree that the appropriate deadline would be deadline 7. That's principally because in a couple of instances, and this does bear on requirement 15, we've got aviation related assessments that are still in train or reports in respect of potential impacts that are still in the process of being produced.
Okay.
And so I think we would be jumping the gun, I think, if we were to be putting in submissions in advance of deadline 7. Now, I know that so far, certainly, the draft MIC has a single requirement in relevant to BAE Systems Operations Limited, which is requirement 15. But if it would be helpful, I can provide an update on the aviation sort of outstanding matters generally, because there may be, as I think we've also talked about before in previous hearings, additional requirements that are going to need to be included in the MIC, some of which we have wording for, some of which we don't. So I think that update in its totality might be helpful.
Ms Sterling, so the additional requirement that Ms Grange is talking about, do you have sight of that?
Amy Sterling, on behalf of the applicant, without preempting Ms Grange, there are 2 additional requirements. So, and 3 forms of requirement, 2 of which are with Ms Grange to comment on, one of which I've been instructed to draft and share with Ms Grange.
Okay.
So across the various different topics.
Okay, so there's a fair bit of progress then. So so deadline 7 is the appropriate deadline for those amendments to the draft MIC, but I believe Mr. Smith previously was referring to some kind of a position paper on some aviation matters. Am I correct?
Indeed, I was, and there was a very specific distinction made by Ms Sterling between the position that we might take there on wake effects, where we could get a Regulation 31 point position paper in, and aviation outstandings, where we could not, because matters were still subject to negotiation. So my understanding, therefore, is that's probably the starting point. But I do think we just need to test that, because, again, just to make clear, projecting forward to the bounce down, we've got to have reached a position where at deadline 9, an applicant's concluded position can be put in, so at deadline 8, a final response by BAE Systems can have been put in, and project that backwards to the current day.
Amy Sterling, on behalf of the applicant, agreed. Ms Grange and I spoke as recently as Monday of this week to set forward our respective positions that we feel that there is movement that can be made, and that any drawing the line under positions would be premature at this stage. So deadline 7 is the deadline that we're working to, sir, and that's when the aviation position paper and any final form of requirements that we're proposing will be put forward on aviation topics.
Okay. Thank you. Yeah, no, that seems fine. And given that this is moving in the right direction, there's no reason to believe that the resolution will not be reached before the close of examination. So I'm not concerned about it with respect to the commentary. So that does that conclude everything for yourself, Ms Grange?
I think it does, yes. I'm in sort of broad agreement with what Ms Sterling has said, and I think we equally would look to put in a position statement at deadline 7. The extent to which we can agree requirement wording for that, we will try, but if there's any differences in terms of the form of wording that we would want to see included in the MIC, we'll make that clear within that position statement.
Yeah, that's exactly what I was going to say. Good. Okay, so that's everything on that matter.
If I may just make one final reminder, and that is, notwithstanding that you're producing a special position statement, and we've agreed that's very useful in the circumstances, if you can at least touch point on this in the SOCG process, so, because thinking of this from the perspective of an examining body in reporting, that will be our first go-to, and if it's neglected there and we don't have a complete picture there, that's a little hazardous.
Okay, good. Thank you. So I'm going to move on now. And we've got 5 minutes to 12:30, and my intention is to cover off these next 3 items in 5 minutes. So we will move at pace. Article 15, I'm not going to give any background. Applicant, you do not believe that Article 15 needs to be limited to order limits. The examining body feels uncomfortable with this, but we're going to go to DOI. Are you satisfied with that? Article 15 is road alteration powers, restoration, and territorial limits. And it does not limit, there's no wording to limit that order to those powers to the order limits.
I think in principle, so Robert Gard on behalf of the Department of Infrastructure, we were satisfied with that because the department retains control, and it is a provision that you do see in draft DCOs that such powers can extend beyond the order limits where it's subject to control. So we have within this subparagraph 3 that effectively provides the consent of the Department of Infrastructure.
That is right, but the precedent that you're talking about is for draft consent orders, for DCOs, development consent orders, and the jurisdiction of that is everywhere. For the MIC, the jurisdiction is just 250 meters landward, so there's a hazard here.
Amy Sterling on behalf of the applicant. It's a fair comment and honestly not one that I had considered, so we'll take that away and consider then the scope of the article.
Okay, thank you. And then just the point about restoration. So it requires agreement for restoration, but does not require approval. And is that old wording that I'm going by? Bear with me.
Robert Garden on behalf of the Department of Infrastructure. There is a requirement to restore to the satisfaction of the department secured at subparagraph 2.
Yeah, I think that was, yeah. So are you satisfied with that wording? Is that restore the temporary to the reasonable satisfaction? Are you satisfied that it doesn't actually say approval anywhere? Must not be exercised without the consent of the department. My apologies. I think this is, I'm going with the older version. Okay.
It does. I
Yeah.
think have an approval in it.
Okay. Good. Move on from this point. Just very quickly to touch on something that we touched on quite a bit at both the ASI as well as at SIH 8, open cut trenching versus trenchless installation, and this is primarily with the beach. And basically, it's just become clear that there isn't a default position for the way that you will, do trenchless installation, or that trenchless installation is not necessarily the default position at the beach, and there are various scenarios and a decision tree, which just seemed very conditional. And the way you described it that day as a narrative seemed to make sense, but in terms of the decision making, it leaves a lot of gaps. Who are you consulting? Who are you seeking approval from? Like, what kind of bedrock will you determine is too sensitive? Whatever that you would need to do. So, we've seen that you have both an offshore crossing schedule and an onshore crossing schedule, and I believe the onshore crossing schedule has been updated once in the examination. So, just wanting to understand how some of these methodologies of what you're going to do in what circumstance, and the schedule of cross. How is all this secured in the draft MIC?
Amy Stirling on behalf of the applicant. The applicant considers that collectively the cable specification and installation plan, for example, the B grant, which is the Biogenic Geogenic Reef Plan, and the outline code of construction practice collectively control the extent of the activities which can happen in this area. The point, I think, is understood, though, that perhaps there's not a single place that you can look to which sets out how the applicant will undertake its construction methodology in and around landfall, particularly open cut, HDD, etc. So we're happy to take that away and consider it. I think I have seen some other requirements which are maybe more specific to that particular area, but I'd have to review. So let us consider that, and we'll, if it's relevant, we can provide an update in the MIC.
You want to comment?
Yeah, Dr. Caroline has reminded me we put in an outline method statement within the outline code of construction practice at a previous deadline, so that perhaps would go some way to addressing this concern. But I probably need to just gather my thoughts. I think I understand the point that you're making.
Yes, and that did indeed seem the natural home, but as currently drafted, it's quite light on detail. So I suspect the detail is there in the application, but it needs to be brought together. A bit like what we were doing on the ASI, bringing groundle into one place.
And I don't know if you agree, Ms. Fernandez, but maybe the constraints map is something that can go into that method statement, you know, just so that there's a way of almost securing it, because there is, you know, there's some level of clarity in there.
Amy Stirling on behalf of the applicant. It is supposed to be an indicative layout, I believe. But yes, we'll consider that.
That's a hearing action. Okay, we'll move on from that. The last point, I'm going to just introduce it in principle because we don't have time to go through it, but we've not talked about Schedule 3, which is certification of documents. And essentially under Reg 40 of the MIR, the Council of Ministers must have regard to the ES in determining the application. And then, you know, the ES has it's a wider function. It's a bit of a benchmark against which you are assessing a lot of the approvals and control plans later on. So during the course of the examination, a number of additional environmental documents have been submitted, as updated assessments, additional baseline. And what the examining body has noticed is that none of that is reflected in Schedule 3. We have done an audit, and we've got quite a long list of documents which we believe should go in there. But we just wanted first to give you an opportunity to tell us what your approach is, when are you planning to update it, etc.
Amy Stirling on behalf of the applicant. If it's an updated environmental impact statement document, including, you know, any baseline, technical appendices, etc., then our intention would be that it should be in there. So we'd be happy to review that and update where appropriate.
Okay, so here's what I'm thinking. Because we've already done this audit, I wonder if it might be an idea for us to actually give it to you on a without prejudice basis. And then you can just use that as a base. So you're not commenting on it, you're just using that as a base to update it. So, and just to give you an idea, at the moment we've got about 25, 30 documents in it that have come in through the course of the examination, which we believe should be certified. So we will give you that list on a without prejudice basis. Okay, good. So, any thoughts?
Amy Stirling on behalf of the applicant. No, grateful to receive it. Okay. And we'll carry out our own checks as well.
Okay. I think just while I'm thinking about it, it might be helpful for us to make sure, obviously all documents that we send out will be published, but maybe open it up to other parties to comment on it as well if you wish.
Robert Gunn, Department of Infrastructure. I think we're happy with that approach, and obviously the department will be the body that has to certify the documents, so we'll just need certainty on that list at the outset, at the end of the examination.
Yeah. Yeah.
Ken Milne, representing DEFA. And as we said before, anything that's got an environmental impact, then yeah, we want to be consulted on, so we support that.
I mean, okay, right, now I would like to move on to agenda item 4, 5 and 6. In the interest of time, and I do want to conclude this agenda item as far as possible, or break for lunch by 1:30. In the interest of time, let's touch on 4 very, very briefly. We do want to touch on it because it sets the narrative and some of the thinking of how, I'd like to approach some of this discussion. So the first point actually under agenda item 4 is really an administrative one. With Planning Act 2008 examinations, there's there's the NPS, so there's a single version of truth. But over here, when I started looking at some of this policy work, I found myself on the internet trying to look for a lot of these policy documents and the latest version and trying to figure that out. So I think that's just highlighted a gap in the examination library, and I think that any policy document that has been referred to by either the department or the applicant, whatever version you're referring to, that as a PDF does need to be appended and then submitted into the examination, because we don't want any, when we get into deliberations, we don't want any confusion on what version we are looking at. So with the planning statement, Ms. Sterling, I think that's a really good home, and we would want the PDF. So don't include links, please. It'll be PDFs appended to the document. And again, I appreciate that this feels like a lot of work, but if other parties have referred to any other policy document, if you could please provide a list of that. So for instance, yesterday, Manx Wildlife Trust referred to the biodiversity strategy. It would be really helpful for you to just highlight that, and we will make sure that those are also then invited into examination. So unless you've referred to it in your planning statement, that if just to highlight those for us. So we'd be really grateful if you can do that.
Amy Sterling on behalf of the applicant, happy to take that action. I would flag there are some instances where parties have referred to policy documents and not provided any references. So, for example, the Biodiversity Strategy 2023 was being referenced yesterday. We're not aware that such a document exists.
Okay.
There is a Biodiversity Strategy 2015 and a 2023 update, which wasn't an update, it was another document, I guess, that sits alongside it. So we could submit both of those together, for example, but we'll do the best we can.
Yeah, I mean, I'm almost wondering where there is discrepancy, you give us a list of what party has made reference to what, and then we will ask those parties to confirm. So I'm just, because we don't want the applicant's version of something that another party might have referred to. So
is there another principle here, which is that at the end of the day, relevant government departments and agencies are the sponsors and owners of these strategies, and or Tynwald owns them, and if they've been approved on a parliamentary footing. I almost wonder whether, actually, I'm not suggesting that the applicant stop the exercise that Ms Sahai has placed upon them, because I think it's really useful in terms of the applicant's own internal processes for the applicant to understand which policies it believes it's subject to and to tell us which ones they believe they're subject to. But I think in parallel, to avoid possible delay, there might be value in one of the government
Cabinet Office.
It's probably Cabinet Office taking responsibility for a systematic breakdown of the strategies that government believes it owns and is praying in aid and would expect Council of Ministers to take into account in its decision, and so therefore we need to consider when we recommend.
Yeah. Thank you, Mr. Smith. I think that seems sensible to me. So we'll issue that as an action. Applicants noted its action and then the corresponding action to Cabinet Office. So quickly moving on. The second point is a technical...
We just have one more request from government, from...
Yeah, so my name is Fiona Heighton. I'm attending on behalf of Diane Brown. I'm from Cabinet Office, from Planning Policy.
Oh, so apologies.
So just in relation to that hearing action, I think that Cabinet Office are happy to compile, a kind of systematic breakdown of the policies that have been referred to, but we would need to work collaboratively with other parties. So we just like to make sure that we've got that buy-in.
Absolutely. And what would help enormously is if this were to come at the Reg 31, even if it has some gaps in it to begin with, because we are now getting close to the end of the examination. So we would really like this to move at pace. So whatever you do, it's almost going to be like a compendium of those policies, then that would need to come into the examination library. And at the moment, I'm going to set Reg 31 next Friday as a deadline. Yeah. Documents, sorry, the policy documents, it's not the policies.
Okay, can I just confirm, would hyperlinks be okay to the PDFs, or do you want the PDF?
No, we definitely need PDFs. Typically in Planning Act 2008 examinations, all hyperlinks, in fact, are redacted because there is a huge risk of, getting the wrong information in. So we've not been that strict here, but in this case, absolutely, it has to be PDFs.
Okay, thank you for the clarification.
Absolutely. We did. Yeah. Okay. All right. Second point's a technical one, and it's to DOI. So we've talked a lot about the strategy of offshore energy production 2014. Just because of the way it's named, I just want confirmation that is that a policy statement that is adopted? What's its status with Tynwald? What weight do we give it when it comes to...
Robert Garden on behalf of the Department of Infrastructure. So that was a policy statement that was subsequently submitted to and approved by Tynwald. So it is a Tynwald approved document.
And so for the purposes of Section 36(5) of MEMA, it's a policy document.
It's a policy document for those purposes.
Okay. So then we get into the substantive point that, and this is to the applicant, and I'm just going by the language that you've used in your planning statement. You have said that with the exception where adverse impacts outweigh benefits, and I am ever so slightly paraphrasing here, but not this next bit, there is a presumption in favor of benefits. And you've repeated that phrase quite a few times. So you've reasoned that with Section 36(5) creates a default position in which policy-aligned proposals with identifiable benefits should be treated as acceptable unless the adverse impacts outweigh those benefits. It's just that characterization, and I want to just clarify, what do you mean by benefits in this context?
Amy Stirling on behalf of the applicant. Well, the 2014 document presents a useful sort of worked example.
Okay.
So in that document, which, yes, we agree was approved by Tynwald, there was, in our view, an established need for an offshore wind project within territorial seas, and that policy need was underpinned by two policy drivers, the first being economic benefit to the Isle of Man, and the second being export to the UK to assist the UK meet its renewable energy targets. Both of those policy objectives are referred to in that document approved by Tynwald. our interpretation of subparagraph 5, it says the Council of Ministers must make their decision in accordance with any relevant policy statement about controlled marine activities in the controlled marine area. Our view is that document falls within that definition, as we've just discussed. And it said, unless satisfied that, and subparagraph D is that the adverse impact of the proposed activities would outweigh their benefits. So our interpretation is that the requirement is to comply with the policy document approved by Tynwald unless the residual adverse effects outweigh the benefits. That assumes that the benefits have, in our interpretation, primacy because they are in accordance with the policy document which has been approved by Tynwald.
And
That's
the benefits, in your opinion, are those two things, energy to the Isle of Man and export to the UK?
Yes, that's the two benefits that are identified in that policy document there, and our view other benefits associated with the proposed developments, such as, biodiversity, net gain, etc., that are more just generally to be weighed in the planning balance.
Okay, so hold that thought. DOI, do you have a different view on that? Or can you corroborate it?
Robert Garden, on behalf of the Department of Infrastructure, that's the view that we have of that document as well.
Okay, good. So let's just move on to 4B then, and let's get on to the relevance of the Climate Change Plan 2022 and 2027. Actually, before we do that, do parties from Treasury and Department for Enterprise want to come forward? Because I know we will want to hear from you shortly. I do apologize, there's only one microphone, so if the two main speakers could sit on either side of the microphone, that would be very helpful. Okay, so let's move on to agenda item 4B, and I want to talk about the relevance of the Climate Change Plan 2022 to 2027 to the determination of the applicant, its status under section 36(5), and then, of course, your how you feel that the current proposed development accords with that policy requirement. So coming to the applicant first and then to DOI.
Amy Sterling, on behalf of the applicant, we can understand that the climate change plan was also similarly approved by Tynwald. I would seek the Isle of Man Government's confirmation on that in just a moment.
Okay.
Assuming that was the case, that could also be considered, although I am not so sure that that does contain a policy statement about controlled marine activities in the controlled marine area, which is the hook for it becoming one that must be accorded to in accordance with subsection 5. My understanding of that climate change plan is more generally the approach on the Isle of Man to work towards its net zero by 2050 target, rather than being specific policy about an offshore wind project, a controlled marine activity within the controlled marine area. Nevertheless, the applicant would consider that it certainly does not conflict with that climate change plan. The applicant has set out in its climate change assessment that the climate payback period for the whole project is less than 3 years, which means that after that it would be providing renewable energy. As we're all aware, the primary export opportunity is to the UK, or the GB grid, I should say. I think one important thing to note, which I think has perhaps been lost in quite a few of the documents, there are many, is that in 2023 that the UK government extended the Paris Agreement to the Isle of Man, which means the Isle of Man is also contributing to the UK's nationally determined contributions and has signed up on an international level to mitigate global temperature rises below 2% in accordance with that Paris Agreement. The applicant considers that the proposed development therefore accords with the Isle of Man's obligations under the Paris Agreement, which are also relevant to the climate change plan.
So that 2023 extension of the Paris Agreement, that's really helpful information. And anything like this that you're now referring to then does need to get reflected. I think it is mentioned in your planning statement, actually. But then if there is any corresponding document, then that needs to get appended. So that's just a reminder. My question here is that I'm not entirely sure we've heard completely. The first part of the question is how the proposed development complies with the climate change plan. You started by saying it certainly doesn't conflict, but I don't think we've heard your arguments.
Amy Sterling on behalf of the applicant. And I think that's because, as I understand the climate change plan, it's about the decarbonisation of the Isle of Man electricity network and then ultimately their energy network more generally. As we've discussed in previous hearings, the application providing an opportunity for a direct decarbonised supply from the offshore wind farm, albeit, as I understand it, the electricity decarbonisation target is for 2030, which would predate when that supply would become available. Nevertheless, our view is that it could provide resilience if Manx utilities did not decarbonise the electricity grid by 2030, noting we're currently in 2026. I think it's also important to note that a proportion of the Isle of Man's electricity already comes from the interconnector with the GB grid, and therefore the decarbonisation of the GB grid logically has benefit for the power that the decarbonisation of the power that flows to the island. So I don't think, based on the specific timescales for decarbonisation of the electricity grid, we could say that it meets that, because we can't meet the 2030 target. But as I think we set out in our planning statement, and certainly our planning support statement, we can provide resilience if those targets are not otherwise met.
Okay. I am keen to move on, but I do want to hear from government departments if anybody would like to comment on one of the largest proposed developments in Isle of Man, and it's, let's say, limited, maybe indirect contribution to one of your key policy and very recent policy documents.
Ken Milne, representing DEFA. We've obviously touched on the requirement in the Climate Change Act 2021 that Tynwald must have an approved climate change plan, and this is the one for 2022 to 2027. So the plan contains policy and proposals to reduce the island's emissions to meet those statutory targets, such as the 2030 targets for electricity decarbonisation. And as has been said by the applicant, and as we've said in our previous submissions. Sorry, I will start that again. Is that better?
Yeah, absolutely.
Yeah.
Thank you.
So there is a requirement in the Climate Change Act 2021 that Tynwald must have an approved climate change plan, and this one sets out the one from 2022 to 2027. The plan contains policies and proposals to reduce the island's emissions in order to meet the statutory climate change targets, such as the applicant has mentioned about the 2030 ones for electricity. DEF have previously commented that these targets in the plan for decarbonised electricity falls outside the timelines of this proposed project. However, that is not to say that the energy produced from the development could not be used by the island to assist in its longer-term decarbonisation as part of its energy strategy. Okay. I'd also like to reference to the application, of relevance to that application, is the Climate Change Act 2020, which also contains a climate justice principle.
Okay.
Defined as the principle of taking action to reduce global emissions of greenhouse gases and to adapt to the effects of climate change. By this definition, the island has a legal duty to reduce global emissions of our greenhouse gases as well as those for our own Isle of Man benefits.
Yeah. That's actually, Mr. Milne, that was very helpful. And it's just given a side of the argument which just completes the picture for me. Anything from you, Mr. Garden?
Robert Garden on behalf of the Department of Infrastructure. Nothing substantial to add. I think the plan is the first step. It refers to setting the island on course and refers to longer term goals of 2050, etc. So nothing further to add to Mr. Milne.
Okay. I've got Ms. Janet Clark online.
Hello, Janet Clark. Thank you very much. Miss Sterling just mentioned that we get energy from the GB grid at the moment. I'm not sure if that's the case actually, because I thought that Peel station was actually supplying the UK at the moment for grid balancing services. So it's the other way around, if that makes sense. I just thought that might be something that needs to be checked. Thank you.
Thank you, Ms. Clark. Who would be the right, Mr. Garden?
Amy Sterling on behalf of the applicant. I would suggest, I think the whole point of an interconnector is power can flow both ways depending on market conditions.
Okay.
I would suggest that that's probably for Manx Utilities rather than anyone in
Okay.
this room, but given I made the point, we're happy to pick up with Manx
Okay.
Utilities on that.
Okay, that's helpful. Thank you. So we'll put that down as a deadline 7 action, perhaps. Yeah, Mr. Strafford, is there a roving mic? Yeah.
Good afternoon. Thank you very much. Just to reinforce that last point, I believe it is correct that actually the Isle of Man actually exports more power to the UK than it does bring, but I'll leave that to be checked. With respect to the 2023 and the Paris Agreement and extending it to the Isle of Man, I think I heard an implication that that therefore put a duty on the Isle of Man to help decarbonise the UK grid. I would like that interpretation to be checked, because the expectation would be in extending it to the Crown dependencies, that would put the duty on the Crown dependency to reduce its emissions, not for it to then go further and start decarbonising the UK. I think it's really important we understand that, because this conversation and the policy seems to lead us down a path where there is a need, and I think that's the word that was used, for the Isle of Man to contribute to decarbonising the UK. And that's a very different scenario to the one which would logically normally follow for a Crown dependency in a country to take its own responsibilities under the Climate Change Act. And I don't believe the Climate Change Act for the Isle of Man is actually intended to be extended to the UK to decarbonise the UK.
Yeah,
and
that's
I think
a really good
important
point.
with respect to benefit analysis. Thank you.
Yeah, I would really like to hear a response from that from government departments.
Ken Milne, representing DEFA. The UN agreements, such as this Paris Agreement, it's for the UK. It's a requirement for the UK. And as was mentioned by Mr. Gardner, it was also then ratified and brought into the Isle of Man. Our Isle of Man contributions go towards the UK, which then report up to the UN. So our wrapped in. We don't submit our own annual emissions, carbon emissions, directly to the UN. They go via the UK as part of the UK submissions.
Okay. Anything further from the applicant on this?
Amy Sterling on behalf of the applicant, only to reiterate that that is the government policy that was approved by Tynwald, that the Isle of Man would lease its seabed for the generation of renewable energy for export to the UK to assist the UK to meet its national and European renewable energy targets. So that is the approved policy of Tynwald.
Okay. I've got a hand in the audience.
Thank you. Just to reiterate what Ian said, the Isle of Man is, I believe, a net exporter of electricity down the cable. But my point really is, we are focusing very much here on more Vannin to meet our requirements to net zero. The MUA are looking at things like onshore wind farms, and a simple solution surely would just be to put another interconnect cable across to the UK. We don't generate on the Isle of Man. So my focus here is, why are we looking at just one option? Why aren't we looking at other options which we know the MUA are already doing?
Yeah. Thank you. I don't believe you said your name. Do you mind?
Sorry, my name is David Owens.
David Owens. I think this is exactly the sort of debate that I had hoped when I put this agenda item together, is to get various interpretations of the policy into evidence before the examining body, because this is one policy document that we've not dissected enough, I believe, in the examination, so that's been helpful. Mr. Strafford, and last point before I move on.
Thank you very much, Ian Strafford. I think it is an important debate because I think the words that have been used today have been that it could contribute to the energy transition for the Isle of Man. A point I wanted to make, and I think this is the right point, at the start of this examination, when we were looking at visual impacts, we were using the word under the planning policy where it did harm, but it was essential. And I think this comes back to this point of, is this essential for the Isle of Man? Or is this something which could contribute later down the line?
Yeah.
As the gentleman has just said, MUA have got strategies, they have got a roadmap. This does not appear in that roadmap to form an essential ingredient that is absolutely necessary, unlike in the UK where it is, if you understand what I'm saying, when you consider a UK application. So I think we're in very different territory, quite literally. Excuse me, but so I don't think we're in a different territory and a different argument, because if this is something which may, then I think, in my view, personally, is I think that also influences the level of weight that is applied to that benefit, recognising that there is a transition plan for the Isle of Man. So I'll just put that out there because that's a very clear issue, I think. Okay,
Mr. Strafford, I think that point has been debated almost at every hearing. So it's not something that's lost on the examining body. We've been asking that question quite a lot, so we're very aware of that. And we're going to come to that a little bit in agenda item 5C and then 6 as well. So keep tuned in. We'll move on to agenda item 5. I'm not saying that I have enough in terms of, these policy interpretations, but I have enough for today. Now, expected planning benefit to the Isle of Man residents and businesses that flow from the economic case for the proposed development. Now, what I want to try and understand here is if the economic benefits identified in the government policy are capable of being considered as important and relevant matters and weighed in the planning balance. Now, I appreciate that this question is probably best goes to the applicant, but given that colleagues from Treasury and Department for Enterprise have joined us here, who have put in representations both at the public consultation stage and more recently at deadline 4, I really want to hear from them in terms of how they identify the economic benefit that's being generated from this, or that will come about from this proposed development, and how you see that as being a benefit for Isle of Man as a whole, including its population, and whether you actually think that that is relevant.
Jonathan Platten for Treasury. As set out in the response at deadline 4 from Treasury Economic Advisory, we would refer to the economic strategy approved by Tynwald in 2022 that set out a key economic priority to generate economic value from the island's resources and to diversify government revenues to pay for public services. In the context of the proposed development, therefore, the economic benefit of the proposed development, as we've also set out, is to in terms of the revenues towards. Sorry,
Madam, do you want to come forward? Do you want to come forward? Would you mind just turning? Yeah. Just speak straight into it like this.
So where was I? So the in the context of this proposed development, the as we've set out in our responses, the economic benefit to the Isle of Man is largely in the government revenue space, in meeting that strategic objective, And as we've also set in our responses, we consider that these government benefits benefit the residents and businesses of the Isle of Man in general through the provision of public services and the reduction of a need for other forms of revenue raising or service reduction that might be entailed were they to be sourced from somewhere else.
Thank you, Mr. Platten. Does Department for Enterprise have anything to add? This has been characterized, and I'm just summarizing the last couple of lines that I've heard from this representation, is that the benefit that's emerging from this project is, and in line with the economic strategy of 2022, is generating revenue. It's primarily government revenue, and it's in that space. And I just want to hear your take on it.
Richard Oliphant from Department for Enterprise. We clearly set out in our response that our interest was in job creation and job diversification. We're clearly trying to understand how the proposal is going to generate new roles within the island. We want those skills to be grown and developed on the island. We're not interested really in skills that may be developed and grown outside of the Isle of Man. We need to understand, therefore, what sort of supply chain activity is expected to be on the island, and whether we can lock in some form of operational maintenance facility on the island, which is going to generate jobs and skills in the future. And this is where we're trying to understand how that might work.
Okay, so this actually quite neatly links back, brings us to agenda item 5B. So you can see my logic in my agenda items. It's economic government in government policy, so that's established. Agenda item 5B is talking about how that economic benefit translates into planning benefit, and we've literally heard two reps right now, which is talking about the economic benefit, and you're talking about how it translates into what, in my mind, is a planning benefit. And so can we just explore that? And applicant, I will bring you in, but I just want to explore how whatever that economic benefit is that's generated from Mooir Vannin, whether it's 2 billion or 1.8 or 2.4, that goes into the government revenue space, how that turns into what you're talking about.
Jonathan Platten for the Treasury. I think those 2 points are slightly different. So the figures of 1.8, 2.4, 2 billion relate to government income. The discussion around the economic benefits in terms of new jobs, I understand to be a different prospect in terms of developing new roles or local businesses or something related to servicing the proposed development and so on. I see them as two separate issues.
So you don't necessarily see the income, the £2 billion, and let's just, for simplicity right now, just say £2 billion that the applicant has calculated will be the benefit that's emerging from here. You don't necessarily see that as trickling down towards, jobs or community benefits or anything directly related to the residents and businesses of Isle of Man as being part of this exercise in terms of us determining what that planning benefit is that's emerging from the Mooir Vannin project.
Jonathan Platten for the Treasury. No, not necessarily. I think that the view of Treasury as set out in our response at deadline 4 was that the growth of government revenues provides public services, and that is the benefit that flows to residents and businesses, that provision of public services, and the collection of revenue in a way that does not rely on raising tax rates, for example, and many other possible outcomes. That is seen as how the benefit flows through to residents and businesses. As to whether additional jobs are created in servicing the wind farm, I think that's a separate issue.
Yeah, I think so. and we will look into that quite specifically later on in session 3. So that distinction, we have made that distinction, but over here I was really hoping to find a way, whether it's jobs or whatever, but to find a way to see what that journey would be from the government income or government revenue and how that turns into benefit for members of the public and businesses who are actually facing the adverse effects that that come about from this project. So I will bring the applicant in a minute, but let me just see if I'll just. Yeah, so applicant, just in response to 5A and 5B, if you've understood my logic, it'd be really helpful to hear your thoughts on this.
Amy Sterling, on behalf of the applicant, our position is that the need for the proposed development and the benefit in terms of an economic benefit and also the energy benefits, which we can come on to, are set at a national level. And in the planning balance, the examining body and ultimately the Council of Ministers should determine whether those national benefits in delivering that need how those balance against the different residual harms, some of which may be local. And in our view, that is how the planning balance should be carried out. We align ourselves entirely with the Treasury submission, which is D4143. And specifically, for example, paragraph 216, Treasury officers do not consider government benefit to be independent of the benefit seen by residents and businesses as a whole, given that government is ultimately controlled by residents through a democratic process and also determines the services provided to residents. This, I believe I made this point at the last hearing. Our view is that a benefit, an economic benefit to the government flows through to the benefit of the residents and businesses in the island through the established fiscal processes and controls which are inherent within government, which the Treasury have helpfully set out in that submission. We also agree that the provision of jobs, O&M-based community benefit, which we don't seek to rely on for planning purposes, biodiversity net gain, etc., sit alongside and complementary to, but are not the same as, the 2 billion, for want of a better figure, economic benefit to the Isle of Man, which sits at the national level.
Okay, let's just take a step back for some of this. So when you talk about when you're talking about financial benefits, when they're sufficiently close to the development that's being proposed, it's very helpful to see what benefit the money can deliver. So revenue clearly would not arise without the wind farm, so therefore there's a connection between the development and the receipt of that income to the government. But it just appears to be more straightforward when the money is committed to a particular project or outcomes that form a part of that development. So you're trying to, are you understanding the connection that I'm trying to make, which is between the adverse effects that's generated from a project and the benefits that are received? There needs to be a close enough connection for us to be able to consider them in the same planning balance exercise. And at the moment, I'm seeing a bit of a disconnect between the two things, with the national strategic benefit going to, to government revenue and the adverse effects being felt locally.
Amy Sterling, on behalf of the applicant, I don't agree with that distinction, Madam, with respect, and I don't think it's the process that we're setting out and the balancing exercise that we're setting out, I would suggest, is entirely compatible to where there is a climate change reduction benefit and a decarbonisation benefit from the project, which is at a national level, which does not necessarily relate to any local impacts which are felt. The climate change obligations sit at a national level. If we're looking at the DCO as a comparison, the established needs for energy security, decarbonisation, those are national benefits which do not necessarily flow directly in the way that you're suggesting, this direct flow to impact the localised harms that may occur to a local wildlife site or, you know, particular views. So we would suggest that our approach to weighing the economic benefit at a national level versus what may in some cases be localised harm is something that has to be considered in the round in the planning balance, and that there doesn't need to be a clear step down.
Okay.
Albeit the Treasury have explained, I wouldn't be able to comment further on how the Treasury manages its fiscal responsibilities, but the Treasury has explained what those are, and that it is confident that the money that it will receive from the development would flow through that process to ultimately benefit the residents and businesses of the Isle of Man.
Okay. I know that there's a couple of hands up, and I'm going to come there, but I just want confirmation around the table between the applicant, DFE, and Treasury, if there is general agreement on this point in terms of the benefit coming from the proposed development is considered the national benefit that is emerging from this project. Yes? Yes, everyone's nodding. Okay. Dr. Allenson, I believe. This should be...
Thank you very much, and I'd like to thank the panel for the opportunity to speak today. My name is Dr. Alex Allenson. I was first elected as member of the House of Keys to represent Ramsey in 2016 and then again in 2021. And since 2020, I've been a member of the Isle of Man government, initially Minister of Education, Sport and Culture, then Enterprise, and from 2022 to earlier this year, held the position of Treasury Minister, and I hope I can address some of the concerns from the panel. Going back to 2021, KPMG were appointed as strategic partner to develop the 10-year economic strategy, and government understood the significant economic damage which would be inflicted on the island due to the global pandemic, but also recognised that the island's economy was at risk of stagnation as some financial services sought to consolidate, and international regulation, especially with respect to corporate taxation, diminished the competitive advantage of the Isle of Man and of other small island nations. The strategy was endorsed by Tynwald in 2022 and set out a vision for the Isle of Man economy as strong and diverse, but also sustainable, ambitious, and built on firm foundations to provide economic success. There was clear emphasis at that time on improving the prosperity for people in our communities, recognising the increased cost of living on the island, stagnant wages, and growing wealth inequalities. And there was also a re-emphasis on the importance of a resilient and sustainable economy, both for individuals and to meet the increasing ESG needs of companies based here and those who want to relocate. I have to point out that the Isle of Man has experienced a real terms contraction in economic output, with inflation-adjusted GDP falling by 5% in 22-23 and an additional 2.5% in 23-24. Similarly, whilst the level of government reserves has stabilised at around about £2 billion, in real terms this has been decreasing, and the latest medium-term financial plan published as part of this February's budget forecasts further dependence on reserves to meet the increasing costs of public services for an ageing island population. To build a more resilient and sustainable economy, KPMG identified in the economic strategy 4 policy-focused areas. The fourth was the monetarisation of renewable natural resources. And as Treasury Minister, I was responsible for producing the island's recent tax strategy, which acknowledged the burden placed on working people to fund public services and our welfare system, and sought to widen the tax base to try to reduce this and increase living standards for all members of our community. Key to this was the protection and nurturing of existing businesses and the sectors seen as key pillars of our society, and the active promotion and development of new opportunities in green technologies, data and knowledge. Now, a lot of work has been carried out by this administration over the last 5 years to protect and grow the island's economy for the benefit of the people, but this has been overshadowed by the fallout of the pandemic, the war in Ukraine, significant inflationary pressures, global political instability, and a series of energy shocks affecting both prices and supplies. As well as widening the tax base, there was a commitment in our economic strategy to generate over £200 million of additional annual income to reinvest in services and the quality of life of our people by 2032. The potential financial and economic benefits from offshore wind development have become clearly an achievable way of meeting these targets. The Economic Advisory function of the Financial Governance Division of Treasury has already made a submission to the public consultation. In it, they've analysed the expected financial benefits should this application be successful.
and they consider the quantum of the financial benefits to be particularly important given the economic strategy's ambition, and see the attractiveness of having a substantial new revenue stream without placing growing burdens on the working population. I also believe that it's important that the Mooir Vannin generation project is seen in the wider perspective of the island making the best use of its natural resources and territorial independence. At the start of the administration, the Energy Policy Board was established to spearhead the development of policies and strategies designed to achieve sustainable, affordable and reliable power to our nation and further the programme set out in the Island Plan. The Global Wind Energy Council have previously estimated that the island has a technical potential to deliver 9 gigawatts of offshore energy, with the Mooir Vannin proposal being the first to prove the concept of such developments within our territorial waters. In 2023, KPMG were invited to give a presentation to the Economic Strategy Board regarding the offshore wind routes to market, how these have changed, and the opportunities to leverage the island's seabed resources through further lease option arrangements with developers. They analysed similar leasing rounds recently in the neighbourhood countries such as Scotland. They gave 3 scenarios of fees based on contract prices and annual option fees for 1 gigawatt ranging from £30 million to £100 million per year, and up to £600 million per year should a 6 gigawatt supply be developed. The option fee potential for the island is considerable and would significantly transform our economy and island finances. This is both consistent with our economic strategy and the Island Plan, whilst also being cognizant of our climate change commitment for a just transition. I'm aware that members of Tynwald have been given legal advice regarding commenting on this specific application. I respect that. However, I'd like to take this opportunity to emphasise the fiscal and economic importance of the Mooir Vannin project to the sustainable economic future of our island and its significance in proving the concept of offshore wind developments within our territorial waters, which could encourage further projects around the island, which would transform our economy and allow us to achieve the government's ambition to increase and guarantee prosperity for our people and communities. I would also like to emphasise the importance of delivering our economic strategy written during the pandemic, but now made even more important following the outbreak of wars in the Ukraine and Middle East. Unless our island innovates, invests and diversifies its economy, we will continue along a path of managed decline, which will ultimately disadvantage all of our community and lead to cuts in public services and benefits, which will rightly be unacceptable to our elected representatives in Tynwald. I'd like to thank the panel for their time today and for giving me the opportunity to speak, but also for the dignified way that they have encouraged public debate and engagement on this crucially important issue for our island nation. Thank you.
Thank you, Mr. Allinson. That's a perspective which I welcome into the examination. Your written submission is something we would like as a hearing submission, so that'd be good. I see a couple of hands up. I'll wait for the roving mic to come to you. Oh, sorry, Mr. Owens first.
David Owens. I think Dr. Allinson, with respect, has just explained why he's resigning as an MHK for next election. But apart from that, Mooir Vannin is coming on stream, as I understand it, in about 10 years' time. Predating that, the 29-30 pink budget prepared by Dr. Allinson shows a transfer to reserves of £37.2 million, and the following year, 30-31, shows a transfer to reserves of £61.1 million. This is before Mooir Vannin comes on stream, and I think is a very relevant point. Thank you.
Thank you. The lady over here, and then the lady at the back.
Thank you. Michelle Cook. I'm a principal stakeholder. I live in Portmore in Mackhold. Thank you to the examining board for visiting Portmore the other day. I hope it was nice, and apologies, I didn't realise you were there, otherwise I would definitely come out with some cold water and magnums, so next time perhaps. But A couple of points here, if I may. Firstly, I think that I'd just like to raise the query that is the examining board examining other forms of income growth that the island should be considering? If you're approaching a new project, I'm a commercial accountant, by the way, so if you're approaching any kind of project, you would look at alternatives. So I think it's really valuable that we understand what they are, the alternatives that the Treasury team and beyond have considered over this period against the wind farm proposal, and on what basis they selected the wind farm proposal or turned down those others, in favour of the others, or if they've gone ahead with more than one. It doesn't necessarily need to be mutually exclusive, that we do this or nothing else. People who are pro this make a consistent message, which is, if we don't do this, what are we going to do for green energy? It's like, okay, let's look at the other stuff. It's not this and nothing. If we don't do this, we're not lost. Climate change-wise, we explore alternatives.
Mm-hmm.
The other thing is about, when you look at a project, I know that one of the bases here is about economic benefits that will flow. As a finance team or an accountant, you'll be told to examine other aspects other than financial. So you've got to look at it as what they call it, a balanced scorecard, and you think, what else is this giving to us? What is it detracting? What are the strengths and weaknesses of all the different components? And what Dr. Allenson didn't mention there, and other people haven't mentioned, is the detriment to the spirit and the soul of the island. I'm not going to go into it, I did that the other day, but I think that comes into play here, that you can't just examine on a financial basis only, even if your basis for the project is financial. It's a weak argument.
Absolutely.
That's all. Sorry, a weak strategy. Thank you.
Yeah, Miss Cook, that point is, I just want to respond to the first one that you said, that, this is not the only thing. It's just a point of clarification in terms of us procedurally. This is the only application before us. So in terms of what our remit is just to examine this application. And that's the point of clarification. It's not a point for debate. That is the basis on which we have been appointed. And the second point, which you said that you cannot just determine the application economically, that's not at all what the examining body is doing. You've seen yesterday we've spent our entire day examining marine ecology. Before that we've examined all the other matters. So, and previously we've, so just to say that we're considering all aspects. I'm going to go to the lady at the back before I come back forward, and we will stop with Mr. Strafford because I think I've got enough from this discussion at the moment. So, was there a hand up? Yeah.
Julia Christine, I'm a Manx taxpayer. I think last time, in the last sessions, somebody was asked why this particular site was chosen, and we were told that it was the only option, and Dr. Allison's just indicated there could be 5 or 6 more wind farms around the Isle of Man. So do we need to go back and look at the other options and decide which is the best one for the Isle of Man?
Mr. Strafford?
Thank you, Ian Strafford. 2 key points, if I may. I think Dr. Allenson has highlighted a fiscal position which would indicate that if this revenue went at a national level, it would sink into a hole rather than be seen in what I would regard as clear public benefit, which I think what, Madam Chair, you were trying to get to were things like new jobs, etc. So I think there is a real concern. There's a real concern within the public that a level of money around the sort of up to say £50 million a year, given the size of the government spending being 3%, and the issues which Dr. Allenson's outlined, if they were to be true, that would be effectively swallowed up in business as usual, if I could call it that. And therefore, I don't believe at a national level it does necessarily translate into a public benefit in the way that I believe these hearings are trying to articulate in terms of compensating for the detriment that is experienced. Additional jobs, I think, are things which are worth exploring, and the papers so far do basically say that for a £4 to £5 billion project for the Isle of Man to receive, and we'll be generous with the numbers, up to the sort of 30 job figure is an extremely small uplift in the working population. But I think in considering even that, it is really important to then consider the disbenefit of each one of those perceived benefits. So the loss of jobs which comes with this being compensated by the new jobs which may come with this, because there's a real danger that the reality of that is it's a neutral position.
And Mrs. Strafford, I think that is something that we will get into this afternoon. But this is helpful. When we get Dr. Allinson's submission in writing, it's a hearing submission, so hopefully it'll be in today. The point that the lady there made about their, the optionality point is something that I am interested to see a response to from both DOI and the applicant in terms of sites. Yes, so that in particular, I am interested to see. I'm not inviting, unless the applicant is absolutely itching to respond on something.
Amy Sterling on behalf of the applicant, apologies. I'm not going to repeat, national benefit to local benefit. I'm not going to repeat how to carry out the planning balance. The panel are aware. The one thing I wanted to respond on was the discussion around alternatives, and I think it is really important to reiterate points I've made at the previous hearing. Is it's not, as I know the panel are aware, the role of this examination or this application to set government policy. Government policy has been clear and consistently in favour of delivering an offshore wind farm in territorial seas for well over a decade now. I would suggest that the question before this examination is whether this application delivers on that government policy, and in doing so, whether the benefits outweigh the harms. So it is not the role of this examination to go and say, should the government have a policy for favour of offshore wind, because that is firmly established and has been approved on many occasions by Tynwald within the policy documents.
Thank you, Ms. Sterling. Okay, so I'm just going to set out very quickly the plan for the afternoon. I do want to return to agenda item 6. I don't believe that agenda item 5C has been fully covered, even though the applicant has given its position on agenda item 5C. I don't believe it's been fully covered, but what I'm going to do is I'm going to ask Treasury and Department for Enterprise to respond to this in writing. And I hope you understand what we are getting at is that I'm in my mind, for the examining body, we are trying to understand whether there is a distinction between economic outcomes and planning benefits, and whether economic outcomes can be treated as planning benefits. It was, the examples of the benefits that both your departments talked about was a very clear articulation of that. And if you can just provide, even jointly maybe or separately, it's you decide, but a response to agenda item 5C, we will find that very helpful. We will return to agenda item 6 after lunch, but I'm going to put agenda item 7 into written questions because there are matters related to the thought experiment which we do want to explore a little bit. So once we come back from lunch, we will do 6, and then the thought experiment number 7 goes into written questions, and then I will hand over to Mr. Smith to cover off agenda item 8, which was agenda item 9, which was held over from SIH 8, and then finish off with decommissioning. Is that clear? If DOI and Treasury can respond to that point, agenda item 5C, are you able to respond to it by Friday next? My apologies, DFE. Are you able to respond by Friday next week? Thank you. DFE have said yes, and Treasury have also indicated yes. Okay. Time now is 1:35. Can we reconvene at 2:30, please? Good afternoon, everyone. The time now is 2:30 p.m. and I'm starting session 3 of SIH 10. We are fairly optimistic that we should be able to finish in by about 4:15. So our intention is to actually carry on without a break, but if we feel that we're going to go on any longer than that, then we will definitely take a break. Does anyone have objections to that? No. Okay. Good. So we will kick off, as I said, with agenda item 6. And I just want to preface this. We've been talking a lot about planning balance today and actually throughout the hearing. And it's just important for everyone to know that, you know, us suggesting that, you know, we're going to, this is enough for now, we're going to move on to an agenda item, or, you know, this part of the argument, and so on, we're still in deliberation. These are all matters that are still being considered, and we are seeking evidence, different points of view at the moment in order to have those discussions. So, you know, it's important to just say that because we're talking so much about planning balance. Okay, moving on to agenda item 6. And what we've got here is that the expected planning benefit to the Isle of Man residents and businesses that flows from the energy generation case of the proposed development. So 5 was all about the economic benefit case. This is about the energy generation case. I just want to say that we understand right from the outset that this is an energy export project. The applicant has made that point very clear. DOI, in fact, have stated very clearly, and indeed supported by Treasury and DFE, that this is all about the export of renewable energy. That's what the government policy supports. Not all about it, but primarily about that. And I just want to again highlight particularly to the applicant, that this is the 5th time that we're bringing this to you, very similar set of questions, 2 rounds of questions, and this is the 3rd round of hearing. So if there's anything further that you can give us in this regard, just understand that this is an important matter where we are still seeking evidence and justification. So if we were to find that the economic benefit case is attracting less weight than you think it should, does that, in your mind, then place greater importance on the direct energy benefits to the Isle of Man? So the energy export case to the UK, do you feel that whatever benefit that is bringing to the Isle of Man, or globally, more generally, in meeting renewable targets globally, would the energy case be increased or the weight increase if the energy was coming directly back to the Isle of Man?
Amy Sterling, on behalf of the applicant, I would consider that they're sort of considered separately because, as you've set out clearly, Madam, the policy demonstrates the need, underpinned by economics, renewable energy to the UK to support the UK meet its decarbonisation targets. I would consider those are the 2 primary benefits of the scheme, which the applicant prays in aid of in its planning statement. In addition, there is the opportunity for an additional benefit of renewable energy directly to the Isle of Man. I would suggest that sits separately to the renewable energy benefit from the proposed development with the export. So I wouldn't combine those 2. I think they are separate.
Explain that point a little bit more, why you think they're separate.
The first is clearly articulated in government policy, that it is an export to help the UK meet its renewable energy targets, with the potential for a future supply at some point in the future is also sort of is recognised. It is, of course, entirely proper for the Isle of Man to have a policy which supports the UK meet those renewable energy targets, if that was the wish of the government, which it seemingly was in setting its policy and having those approved by TIMWOD. As I've mentioned, the Paris Agreement has been extended to the Isle of Man. The nationally determined contributions are reported together. We heard that from DEFA. Also, of course, the key point is that there is a high level of certainty in the export of renewable energy to the UK, which is not the same at the moment, for reasons I'm sure we're about to get on to, in relation to the export of energy from the proposed development to the Isle of Man. So the government policy isn't to have an offshore wind farm to decarbonise the Manx electricity grid. That's not what the policy says. The policy says to have an offshore wind farm to decarbonise the UK grid and help the UK meet its targets. Now, I say that we firmly have demonstrated that we can meet that policy objective. So I would suggest that they do have to be treated separately because they are treated separately in policy.
So I appreciate that, but I'm trying to understand. So the case that you're putting forward is the economic benefit case to the Isle of Man, then the decarbonisation of UK as the second part of it, and then the third part of it is decarbonising the energy grid in the Isle of Man, and you feel that these are three separate cases that you're putting forward.
Amy Sterling on behalf of the applicant. Yes, that's correct, madam. That's how we structured it in our planning statement, planning support statement, now planning statement, and we suggest the weight that can be attached varies. So if we were talking about specifically the power from the wind farm to the Isle of Man, we recognise in our planning documents that the proposed development will not contribute to the 2030 decarbonisation electrification targets due to project timescales. We do set out, however, that it would provide an opportunity to assist in meeting net zero targets by 2050 if those were not met by other means. We recognise in our planning statement, our planning support statement before that, the uncertainty which currently attaches to the island link solution for matters, which are not entirely within the applicant's gift, as we've already examined in great detail. And in our planning statement, therefore, we suggest that moderate weight should be afforded to the opportunity which is afforded by the proposed development for that connection. We suggest that the moderate weight to be afforded to that opportunity sits entirely separately from the weight to be afforded to meeting the policy objective of taking renewable energy to the UK.
Okay. Any questions from my fellow panel members? No? DOI, do you have a comment on this?
Robert Garden on behalf of the Department of Infrastructure. Again, I think that's the characterisation that the policy sets. It sets export as the driver and economic growth there. I think in terms of your question, I think the way you framed it was, would a reduction in weight to the main purpose contribute to an increase in weight? But I think for the reasons that Ms Sterling has just articulated, I think you have to treat them in all cases as separate benefits to be assessed.
Okay. And before I come to the lady with her hand up, I just want to check with DFE and Treasury if there's anything that you would like to add to this.
Jonathan Platten for the Treasury. No, I agree with the DOI comment just now.
Okay, DFE have also said they agree. All right, Ms. Strafford, I believe, the mic's on its way to you.
Yep, Ali Strafford, resident of Isle of Man. Please, could we just have a reference for the policy document that states that it's Isle of Man government policy to support the decarbonisation of the UK grid? I've read policy documents and I've seen where it's policy to get economic benefit, that's why we're doing this, for the financial gain. But I can't recall seeing where it says that it is Isle of Man government policy to support the decarbonisation of the UK grid. I'm not saying it's not there, I just don't know where it is. I'd like to get the reference for that document, please.
Yeah.
Amy Sterling on behalf of the applicant. There are various references set out in our planning support statement and our planning statement, but I would, in the first instance, direct the examination to page 6 of a report by the Council of Ministers on the strategy for offshore energy production, which, as we discussed previously, has been approved by Tynwald. I read it this paragraph earlier, but I will read it again. A significant opportunity therefore exists for the Isle of Man to lease its seabed for the generation of renewable energy for export to assist the UK to meet its national and European energy targets.
Mr. Trafford?
Thank you, Ian Strafford. I recognise that paragraph. I've read it numerous times within the energy strategy. I think the emphasis that's being put there is an emphasis that the primacy of that strategy is to decarbonise the UK grid. The primacy of that strategy is under the energy strategy was to take advantage of the opportunity to sell renewable energy to the UK, because that's a UK policy, in exchange for revenue. And I think we have heard this morning that the prime purpose for this was revenue generation. The primacy of that strategy and the interpretation of that strategy to imply that the prime purpose is to support renewable UK energy production, I believe is not the correct interpretation of that strategy. But obviously that would be for DEFRA and DOI and the Treasury, I guess, to...
I think that's a very crucial distinction. I would like to hear government bodies respond to that.
Yeah, Robert Garden on behalf of the Department for Infrastructure. I think throughout the document it does refer expressly to export to the UK as a primary objective, and it's captured in the conclusions. So I think that is how we have read the 2014 report, and I think they are two separate benefits. I think the primary benefit to the Isle of Man is clearly the economic growth, and that is I think the way it's been characterised today, but the export to the UK is recognised within that as the means to market and also means to deliver the project.
Yeah, I think that is a helpful nuance, Mr. Strafford. I would ask the applicant to perhaps take that away and just give it some thought. And if that emphasis you believe, after hearing that comment, is ever so slightly misplaced or should be reassessed, then do reflect that in your planning statement. But
Amy Sterling on behalf of the applicant. I'm confident in the emphasis we've provided, and I'm confident that it's consistent through the government documents. We have set them out in our planning support statement. We will update our planning statement as referenced in Deadline 7. Ultimately, obviously, I'm not the final arbiter of how the policy should be interpreted, so other people have their own views.
Okay. I'm quite satisfied to close this agenda item down. And once again, just to re-emphasize, closing an agenda item doesn't mean that we've finished deliberation. But we have enough in terms of arguments for now. We will seek further arguments in writing. Now, before I hand... there is a hand up on the screen. Ms. Clark?
Oh, thank you very much. Janet Clark, resident of the Isle of Man. I just wanted to say that I've not seen any costings for how much it will cost to bring energy to the Isle of Man, either directly or via a new interconnector. Because I think our existing interconnector is only 65 megawatts, and we need 80 megawatts firm for one thing, so we'd need a new interconnector. Plus, from what I understand, there was a document back in 2020 from, I think it was from DEFRA, that said that it would be about 16.4 million a year just for the integration, plus about, I think it was 110 million as a one-off cost, which is really high. And I just like to say that unless there's been no costings anywhere at all, I did some costings myself, comparing it to a different plan, and it worked out like about double on the different plan. So I think that it could possibly be a disbenefit, not a benefit, bringing energy from Mooir Vannin. If we can do it cheaper in a different way.
Thank you, Ms. Clark. A lot of what you've said, you are reporting from memory. I think if you want us to give that evidence weight, we will probably need to see it in examination. So if you can provide the argument supported by the evidence, we will take that into consideration. But for now, because that is not before us, I'm not going to seek a response at this moment.
Thank you. Yes, it's I will put it into evidence. It's a document. It's called Appendix 16, and it's a government document of 2020. But I'll put it into evidence.
Okay.
Thank you.
Thank you, Ms. Clark. Good. I've got another hand up. Garth Commissioners.
Yeah, I realise you need to move on from item 6, but the comments I've got to make do pertain to item 6, and I wonder if I might just be able to put those in from the Garth Commissioner's point of view, if I could. So you'll have to forgive me, but I cannot talk at great length about the technical details or legal aspects of this proposal, all of which we've heard quite a lot of this morning. I can only speak from the aspects that concern Garth Commissioners and residents, and as such, I'd like to ask you and the other board members to bear with me and hear my submission and the summaries of document D4150, and this totals 8 minutes. Now I did.
Mr. Henthon, I don't think we'll be able to afford you that kind of time.
Okay, but I did.
But what I would suggest is if it's a summary of a document that's already in examination, then I do recommend not repeating those points here because it is already in examination. So, you making those points again does not reinforce them.
I understand that, Madam Chair, and I will cut out those particular parts, but I did actually time Dr. Allinson's speech at 8 minutes and 37 seconds. He was afforded, and he's not even the Treasury Minister anymore, he was afforded the time to talk at length about his particular take on things. So I think as the Garth residents, Garth Commissioners are most affected by this whole proposal, I with the greatest respect, I'm also the chair of 2 boards, and I also give time to people to put their voice across, and I would like a little time, and I will try to cut it down to as little as
Mr. Henthon, I'll give you 4 minutes.
Oh, blimey. Right. When do we start? Okay, so Garth Commissioners submitted a summary of the 140 questions filled out at the Garth residents meeting, and of the 72 selected, the summary document D4150, 69 of those respondents are against. And whilst there are supporters within the community of Garth, the commissioners are stakeholders in this process and have a right to put those views across. We're here to represent the majority of the Garth residents, and we feel after 2 public meetings we have concluded that we are against this proposal. Without going through all of the submitted questionnaires, there are all negative comments. I will now cut out all of those negative comments because they are submitted in the document. So how much is a Manx resident's opinion worth, and who has the right to overwrite this and sell off the things we treasure? Therefore, on behalf of the majority of the constituents of Garth, I respectfully ask the panel to consider the following question on behalf of Garth and the island residents. Does this scheme's disbenefits outweigh its benefits? How, after all the information we have gathered and read over the past year, have we come to this conclusion? Most recently, the current head of Octopus Energy in the UK has stated last week there is too much energy focus on construction of wind turbines in the UK, and it does not require any more energy generation. What the UK now requires is investment in infrastructure and distribution of the energy network. So as I see it, the UK energy providers don't need it. It completely ruins our sea horizons, vistas and sense of island nation. This is all our Garth residents. It will undoubtedly affect the unique heritage and tourism. It will endanger our registration of the UNESCO biosphere. Just been stated just 5 minutes ago, it does not benefit the island's net zero target, just the UK's. Amy Sterling, for the applicant, just said that. I will refer with, it will interfere with vital shipping routes and cause more cancellations. If it comes ashore, It doesn't help when the wind doesn't blow unless we spend millions on storage. Therefore, the power station has to keep going at full speed, so it's not green. If the power comes ashore, it's going to cost the Manx taxpayer millions to connect it all up, store it, manage it through our bills, loss of revenue or direct taxation. Mooir Vannin admitted that it will cause disturbance and possibly destruction to the marine environment nearby during its construction, again during its deconstruction. So in summary, I would say there are more disbenefits than there are benefits. There is one positive. It will tick some boxes in the UK's green agenda for Mr. Miliband. Am I all right to say that name? I'll say again, if the examining board calculate the benefits against these disbenefits, they will find that this fulfills one of the 5 grounds to refuse this application under section 36 of the MEMA 2016 document. The disbenefits do outweigh the benefits, and under section 36 of the 2016 MEMA document, this is grounds for refusal. If we make a less than 3% saving in government spending through efficiencies, it would give us the same income per year. And if we take the new reduced array down, it will reduce the income and therefore make it easier to achieve a target of savings, and we won't have to sell our heritage down the road. The income indicated would not easily satisfy even 1 year's budget for our health service, Madam Chair, and I've cut that down to as far as I can, okay? And that's the views of Garth residents and Garth commissioners, and we have sat through an awful lot of technical information, and that's just some realism.
Mr. Henton, just to let you know that I recognise the evidence that you just put forward. It came to us at the public meeting, and it is also in evidence in writing as well. So thank you very much. You're right, this was the relevant agenda item, so you spoke at the right time, and it's all recorded. It is before us. Thank you. Good. Now, before I hand over to Mr. Smith to take over the rest of the day, I did want to talk to the applicant a little bit, to continue the conversation we were having at SIH 8. And this is to do with the Scheme 2 thought experiment. Now, there's one thing that, Ms. Sterling, you said yesterday, is that you would not submit Scheme 2 thought experiment as a change request, but you were prepared to submit Scheme 1 proposed changes as a change request if we suggested that that was the procedural route we'd like to take. Can you tell us why the distinction between the two?
Amy Sterling, on behalf of the applicant, yes, if you want to go through the process, Mr. Yates is prepped for both of those. Scheme 2 doesn't represent the scheme that we wish to see consented. It is a without prejudice scheme that we've put forward that we consider the examining body could recommend or the Council of Ministers could grant within the application already before you. If we couldn't make a change request for the without prejudice case, because that would have effect of changing the application for the proposed development, which is currently before you, and that is not the intention of the without prejudice thought experiment. What we would be happy to do is to submit what we are willing to do is to submit a non-material change request for the 4 MDS changes and soon to be 2 to 1 OEC changes through a non-material change application. We're also happy to provide more information on the Scheme 2 proposal on a without prejudice basis, but not as subject to a formal change request, because we're not seeking that change to the application. Okay. So, for example, if I were to submit a non-material change request to reduce the turbine numbers from 87 to 72, we would never be able to build 87, and that's still our primary case for consent.
I understand that. So there's 2 or 3 problems with that. So first is that if you put that the Scheme 2 thought experiment before us, but you don't actually change anything or reduce the parameters that you're applying for through the draft MIC, if we were to rely, for instance, on the reduction of the adverse effects, we could never be certain of it.
Amy Sterling, on behalf of the applicant, no, I disagree with that characterisation, Madam, because we're offering to provide you without prejudice documents, such as a without prejudice draft MIC, without prejudice works plans, and without prejudice management plans, which you could then use in your recommended MIC to secure the necessary design refinements and also the necessary mitigations in respect of that without prejudice scheme.
How is that different? Now, I understand what you're saying, and this is something the examining body considered at length yesterday, is that if you submit it, for instance, as a change request, let's say we deem it non-material and we accept it into examination, we're potentially eliminating the option of building the larger scheme with a greater energy generation. And we considered that. However, consider this, that what if the change request is crafted as an insertion of an option rather than a substitution of the primary scheme? Look, the reason that we are asking you this question is because we're looking for a procedurally safer route. If we were to go down that route, we're looking for a procedurally safer route, and I do believe that there is a risk associated with accepting the thought experiment into examination as an option and just advancing that to the Council of Ministers as our recommended scheme. So in order to mitigate that risk, you might consider that change request is crafted as an insertion of an option rather than a substitution for the primary case. So DCOs do have options, for instance, in terms of cable routes, design choices, etc. So, and then the change does not affect the primary option scheme. So essentially, you are still leaving the two, and the way the examining body is looking at this is that you're putting before us two planning balance options, yes, and that's how you've presented it on Wednesday as well. Those planning balance options remain before the examining body, but one has come through as a change request, but it has come through as a change request as an option into the draft MIC.
Amy Sterling, on behalf of the applicant, I do understand what you say, madam. I don't agree that there's any procedural risk with the approach for the thought experiment for the reasons we set out in our hearing submission. I would flag that the option of Scheme 2 is already inherent within the MIC for the reasons we discussed. So I'm trying to consider, so would the non-material change say the applicant may either build Scheme 1 or Scheme 2, and then the examining body would choose between Scheme 1 and Scheme 2 in its recommendation? I'm not sure how different that is. So sorry, I'll just repeat what I was saying. Yeah, if what I'm trying to understand what the non-material change would do. The non-material change would say in the description of the authorised development, the applicant may build either Scheme 1, well, a scheme within the maximum design scenario for Scheme 1 or a scheme within the maximum design scenario for Scheme 2, and then the examining body would decide which one to recommend within its draft MIC. I don't...
Or potentially even recommend both, giving its reasoning to the Council of Ministers of what is its recommended option in terms, in planning balance terms again. What I'm trying to tell you is that, and if you just for a few seconds drop the non-material from the change request, you will understand why we consider it a risk. It's not determined, it is not established that it'll be non-material until we have determined its materiality. So the risk always remains before us that somebody later down the line, Council of Ministers, determine it to be a material change, which we have put through as changes through the draft MIC. That is the procedural risk before us. So, and if that procedural risk remains, you're essentially taking that option off the table. Now, I know that that's not your preferred option, but you've advanced it to us for a reason.
Amy Stilling on behalf of the applicant. Firstly, apologies, it's just a force of habit because the section says non-material change. That's what I refer to. I wasn't even conscious I said it. We hadn't thought about it the way that you've suggested, in all honesty. We hadn't thought about having scheme optionality within the draft MIC, so I don't currently have instructions on that. Okay. That's not a way of an approach we'd considered. So
Okay.
I would have to take that away and discuss with my client because I don't have instructions. But I can understand now the intent and how that might be structured within the MIC.
Okay, and let's get into the timetable. But let's just put that aside for 1 second because there's another nuance that we just want to put to you. And that is related, it's been brought into sharper focus because of the thought experiment, but it's something that's actually, even without the thought experiment, is a problem that we've come upon in the project. But Ms. Cook, can I take your comments first?
Thanks. Thank you. A couple of things. It strikes me that because we are very close to the end of the whole process, we're no time away from a decision. It's really late in the day for a change in the size and scale of the development to come in. Think that we're looking at a 25% drop in revenue for only a 17% drop in the number of turbines. So we're ending up at 83% of the size of the project for a 25% drop. So the drop in revenue is greater than the reduction in revenue to the island is greater than the reduction in the size of the wind farm.
Ms. Cook, you've made this point before. You made this point before
but
yesterday.
It's really late. Okay, so I'll get to my point. If we haven't considered, we're not going to get the chance to consider anything as a public being because there's no time to put this through public consultation because this suggestion has come in after the public consultation has closed. If it were a 40% reduction in the scale of the wind farm for a 25% reduction in revenue, then maybe people would think, okay, all right, I get that. But the people that were pro the thing to begin with might not be pro now because the revenue isn't good enough.
Yeah, that's a good point, and those are points that we need to take into account, which is one of the reasons why we definitely want it at the moment, because we're still in examination, still collecting evidence. We want to make sure that both options are before us because we are not in a position, the examination has not closed, we don't have all the evidence before us to be able to determine, oh, I think we'll prefer that. Yeah. So that is one of the reasons we're having this conversation. So the points you've made are well made, and that's exactly the sort of planning balance exercise. I think I've said it 30 times in the last half an hour, but, that's the kind of planning balance exercise that we need to take into account. I just want to clarify one point, Ms. Cook, that it is not quite as simple. The planning balance exercise, or indeed the applicant's exercise, is not quite as simple as a 25% reduction versus a 17% reduction. And there are lots of other factors. So the adverse effects are through a range of environments, and the benefit reduction in benefit would also be able to take it. So we've not been able to process it because, as you know, it's only just come to. But those points you've made before, and those points are they're noted.
Thank you. I understand that there isn't a direct correlation between the number of turbines and the revenue per turbine. I get that it won't work like that. There are other considerations. My point here really is about the lack of opportunity to consult the public on the change in the revenues of a project which is about revenue, about economic benefit. Those economic benefits have changed fundamentally after the public consultation period. Yeah. So I don't, that's my point. I know it's great and you're going to take that into account, even though it's really late, but the public can't. And I'd also make the point that it's really difficult for anybody to understand anything because we don't know the breakdown or the split of revenue generated by rental of the seabed versus revenue generated from reduction in electricity, for example, nor the difference between that and this tax revenue thing that we keep hearing about, which, I've raised these points by submission. We just don't understand them. We don't know why there isn't a mitigation fund, or if there's going to be. We don't know what the reduction in the blighted industries is going to be, and if this 1.8 million includes all of that, or if it's been netted out of it. We don't
Yeah.
know if anything's net or gross.
Yeah, Ms. Cook, you've made those points, and it's the parts of the applicant's ability to deliver the project, the financial ability to deliver the project, is that we need to take into account in our consideration. We are pursuing those. The rest of the questions that are not within the remit of our examination, it is up to the applicant to respond to. So you repeating those points here today are not reinforcing them, as I have repeated many times. So I just, the point that you've made about public consultation, just a slight nuance here. This is not public consultation. This is examination. Public consultation has already happened.
It's my point. That's my point.
But if you look at my agenda for SIH 8, that is one of the key questions that the applicant is going to respond and will be a part of our consideration, is that whether the applicant would have met its requirements to consult on a scheme which is potentially quite different. The applicant might, and the applicant is going to respond to that. But
Amy
thank you very
Sterling,
much.
On behalf of the applicant, I'm sorry, madam, there are a couple of things I have to clarify. The scheme is not quite different. The scheme is within the maximum design scenario that the applicant has always consulted on and has always been subject to this application. The applicant is also not introducing it late. The applicant introduced it at approximately the halfway point of examination, with 4 examination deadlines, now 5. Still remaining, a full round of hearings, a full round of written questions. There has been ample and remains ample time for parties to comment on the without prejudice case. We entirely dispute that there's not sufficient time left for people to speak.
Ms. Sterling, I think there's a lot of validity in what you've said, but we had said to you at the PM that at the very latest, the drop dead date for any kind of amendments or change requests would be deadline 5. So essentially, you have well crossed that threshold when you even introduce this idea into the examination. But that's not the matter. We are trying to work with you here, and we will give Mr. Yates a chance to talk us through how this is possible. So you must understand that the examining body is trying to work with you in order to see how this can be accommodated. But the point about consultation, I'm not going to seek a response here because the applicant has that as an agenda item that they will respond to. So, okay, thank you. So I think the only thing that is left now for us to do is for Mr. Yates to talk us through how, if we were to go down the procedural route of a change request, how that would work within the rest of the timetable.
Toby Yates on behalf of the applicant. Before I start, can I just clarify if you're referring to the thought experiment there or the design refinements?
Bear with me, sorry. Yes, absolutely, yeah. Did I already put the question to them? No, not yet. Okay.
And it would be better.
Actually, Mr. Yates, I think the point that we do want to explore is probably slightly more important than this timetable. So let me just get my last question out. Okay, so the next thing was, sorry, I completely forgot, I'd missed that. No, it's fine. Yes, so the next point is that and let's start with the Scheme 2 thought experiment. There's large bits of potentially unused land. You've already identified roughly half the array area that you will not need if you went ahead with that change. If we were going to rely on the reduction of adverse effects, we would probably want absolute certainty that those adverse effects are not going to take place. So our question to you is that if you're not going to use bits of the land within the order limits, what can you do to remove them to give us that certainty that there will be an absolute reduction in the adverse effects?
Amy Sterling, on behalf of the applicant, this relates to the distinction between works areas and order limits.
Okay.
So the applicant would reduce, in the thought experiment, the applicant depicts a reduction in works numbers 1 and 2, which are the wind turbines and the offshore platforms, and those are the works packages which give rise to likely significant effects primarily for SLVIA. Works number 3 and 4, I think it might only be 3A, I don't have them in front of me, 3A and 4, would continue to be required in the, I think what you're referring to is unused land in the unused area, but those are subsea cables, and those are required because they will require to connect the substation platforms within work number 2 in the array to either the Isle of Man in the case of work number 3A, or the East Irish Sea transmission cables in the case of work number 4. It's not possible, as I understand it, to identify at this moment in time where the offshore platforms will be within the array. That's subject to detailed design. Therefore, the flexibility is sought to put those subsea cables within the areas where the wind turbines and offshore platforms also used to be, so that they can make the relevant connections. So there's no reduction in order limits, but the combination of the way the powers are structured and the articles are structured in the MIC, which relate to the works as described on the works plans, would mean that work number 1, the wind turbines, could only ever be in that smaller area, and work number 2, the offshore platforms, could only ever be in that smaller area.
Okay, so that is helpful. There was quite a lot of detail in there, so I don't think I've clocked each one of those details, but I think generally in principle, it's roughly what we were talking about. Is it not?
At risk of moving down rabbit holes into detail, but I mean, there is this broad question about the implications of the thought experiment, and as Sterling, you've set out one of a number of mechanisms that might prospectively address the point that Ms. Sahai has raised. But there is a different matter that also relates to unused land. For example, when we were, and this is land, terrestrial land, not land which comprises sea. When we were at the Groudle Bay landfall area, amongst other things, we were looking to locate the works areas within the red line boundary, and that was done very clearly. And as a consequence, there is an arc of land, if I can best describe it as that, which extends above Groudle Beach, essentially seaward of the existing cottages up to the main road, where there had possibly been, in the contemplation of the applicant, a road access point, but we clarified it with Dr. Caroline on site that that was no longer in prospect, so that wouldn't happen. So we've ended up with a parcel of, or parcels of land which are within the red line boundary, but for which there is now no specific works description or use. Now, there is a residual concern about that, which is that were an order to be recommended and made, that red line boundary would apply and prospectively burden, now there are some arguments about what the effect of that would be, land that is not yours. There are no compulsory acquisition powers invoked, so you're not going to acquire that land. But if somebody wished to use it or develop it, or mortgage it, or use it as security for finance, or anything more broadly, that they might struggle in circumstances where it is burdened by a red line boundary authorising aspects of use or development where in fact it's your clearly stated intention that you don't propose to carry anything out. So there was at least a starting proposition that where that's true, either a means of hatching or annotating the remaining land area to make expressly clear that there are no remaining works powers applicable to that land, or alternatively just pulling the red line boundary back to make it utterly indisputable that it's no longer within the red line boundary. Or another solution, if you can think of one.
Amy Sterling on behalf of the applicant. Yes, noted I wasn't on the site visit, sorry, but Mr. Carolan is concurring with you in my ear. So on that basis, I don't have a firm proposal as to how we could deal with it. As you've mentioned, there are a few options. We could colour the land white, which means the works packages would no longer apply within that area, or the red line boundary could be trimmed in that area. I understand that at that point, and my instructions are that we would seek to take an approach to reduce the flexibility for design in this area. I don't have exactly how that would be done right now.
Yeah. Ms. Sterling, I think what would be helpful, I think we're converging rather than diverging, so that's good. All I would say is that I'll just put forward a couple of considerations that this would have, that we would need to take into account. So one is that with respect to the thought experiment, it's about it's about us having the certainty when you do your environmental ES table, for lack of a better word, we would want that corroborated with this reduction in the extent of the proposed development. So where you can build, where you can't build. So, the reduction of the adverse effects that are being generated because of the proposed development, and for that to be corroborated by a corresponding, again, for the lack of a better word, land plan within the order limits. And then the other thing is it's about the fairness point, which Mr. Smith has already raised. Appreciate that CA has not been is not engaged in this application, but if certain areas no longer have an identified development purpose, then is it even legal to have that within the order limits? So, first of all, a response to that, but I think that will be something that we'll have to take into account when we're advising Council of Ministers. And of course, I am talking about this very much from the point of view of the thought experiment scheme 2, but Mr. Smith's point is that that actually applies a bit more widely to the scheme as it stands, and not just with the land that has been identified, but potentially even with the reduction of the cable circuit at Groudle Field. So, but I think the suggestions that you have given seem sensible. They'd need to be quite watertight, but potentially corresponding provisions in the draft MIC. So if you could take that into account, that would be really helpful. But good, I think that covers it. Good, let's take about 5 or 7 minutes with Mr. Yates, and if you can talk us through. Sorry, what's that? Oh. I don't know. Ms. Sterling, we did not establish when you would come back to us about the introducing an option in terms of the change request. So putting forward a change request which introduces an option into the draft MIC rather than a very clear one or the other.
Amy Sterling, on behalf of the applicant, I currently don't have any instructions to do that, so that would be my first port of call. Mr. Yates is just about to incorporate that question into his either/or scenario of, if it's a change request for Scheme 1, this is our proposed timeline. Okay. This was our proposed timeline for the thought experiment. We'll need to take instructions. If we were to combine the two into a single change request, here's the timetable. That's what Mr. Yates is going to work through.
Okay, great. We're ready.
Thank you, Toby Yates, on behalf of the applicant. I'll start with Scheme 1 in the first instance. And as sort of set out, I won't go over it in too much detail, but unlike the thought experiment, this is the design refinements that the applicant is proposing as part of its application. Therefore, it's a question of process as to how to incorporate it as part of the application.
Sorry, Mr. Yates, just to be clear, so you're talking about Scheme 1 at the moment?
Yeah, so
Yes,
the four
okay.
design refinements which
Yeah.
were introduced in
Got
the
it.
Deadline 5 cover letter plus the
Okay.
fifth design refinement referenced in the Deadline 6 cover letter. So I guess just to set the context before I go into a specific timeline, we've taken the actions this week for a hearing submission on Monday to explain with reasoning why the environmental effects of those 5 design refinements would not be worse as a result of those design refinements being incorporated. Now, a big part of a non-material change application would be a collection of the change or not on environmental effects. So what we were going to suggest, or what the applicant does suggest in relation to Scheme 1 and design refinements, is to run a non-material change application, if that's what's required from the examining body, in parallel with existing examination deadlines. So our suggestion would be that if the EXB is so minded to request a non-material change application, if that is required from the examining body, then we'd suggest if that could be formally included in the actions that we expect to be published on Monday. The reason I say assuming that's required is because the applicant's position to date has been, with them being design refinements, we've already captured them as part of the application documents.
Okay.
So if that comes through on Monday from the examining body, then the applicant suggests that by the procedural deadline of next Friday, the applicant would submit its non-material change application for those 5 design refinements, and that would include in full the environmental effects information that you've asked for Monday. We'd push that and collate it all into a non-material change application to be submitted on Friday. We'd then suggest that between that procedural deadline on Friday, which is the 24th of July, between that period and the 17th of August, which is the date of deadline 7, we'd suggest that that period is used for the examining body, pursuant to its obligations under MEMA and the regulations, to consider in the first instance the materiality of those 5 design refinements, and if those design refinements are determined to be non-material, then the examining body has opportunity to invite written representations in relation to those 5 design refinements. And the statutory minimum, just for reference, 'cause I think this might be relevant when we talk about the thought experiment, the statutory minimum period is 10 days. And the gap between the 24th of July and 17th of August I make to be 24 days. So that gives approximately 2 weeks for the examining body to determine materiality and then carry out that consultation process for interested parties to then submit their consultee feedback at deadline 7 on the 17th of August.
Sorry, can I just stop you there? So we would have to determine materiality in roughly 2 days over the weekend to issue consultation on the Monday.
Toby Yates on behalf of the applicant, so 2 weeks, sorry, not 2 days. You'd have 2 weeks.
I see. And then 10 days following the 17th of August.
So if you took the full 14 days from Friday the 24th to determine materiality, you'd then still have the 10 days left to allow consultees to submit their feedback at deadline 7. And as Ms Sterling said, obviously the refinements have been in the examination for a while, so that information's available already.
Understood, yeah.
If we flow from there, then deadline 7 being the 17th of August, the applicant would submit its next iteration of application documents at deadline 7, and effectively what we'd have to do there is undo the design refinements that were incorporated at deadline 6, because that'd be on the basis that those 4 design refinements won't have been accepted into the examination, because the examining body would have determined they're not just design refinements, they need to be submitted as part of a change request, and therefore we couldn't have them as part of our application documents anymore. So we'd have to undo that.
No, let's understand that a bit more. Mr. Yates, if we're still talking about Scheme 1, you'd not need to undo anything.
Toby Yates on behalf of the applicant. Well, to clarify where I was coming from there is, There'd be other updates to the draft marine infrastructure consent that we'd be making for deadline 7.
Okay.
And that would be as part of our ongoing application, which is parallel to the change application. And for our primary application, the MIC that goes in, if they hadn't have been accepted into the examination yet, because the ongoing process as part of the change application was still to be determined, then that primary application that was submitted at deadline 7 shouldn't include those design refinements. And I suppose, just to clarify, if I can, it comes back to my point around whether we need this change application at all. The applicant's position is that, well, this is the whole point, we don't. It's already available for effectively consultation. It's been submitted at earlier deadlines. That information is available. All we'd be doing here is submitting a draft MIC on Friday procedural deadline with those design refinements. That's already available. And it would then be for the examining body to consult. And our position is that those design refinements are already available for comment. So the position for the applicant primarily is that we don't need to do this. But if that's not the view of the examining body, then it'd be parallel processes. And where I was getting to there is post deadline 7, but ahead of deadline 8, having received consultee feedback, if the examining body determined that the change application is non-material and can be accepted into examination, then at deadline 8, the applicant would combine it all back into a master set of documents that would become its primary case for the application. It would be all 5 design refinements as well as any updates that were made in isolation at deadline 7.
Okay. And now let's very swiftly move on to Thought Experiment Scheme 2, introduced as a change. This is obviously without prejudice because you're of the case that you've already made.
Toby Yates on behalf of the applicant. So as Ms Sterling set out, I won't be able to run through a suggestion for it on a without prejudice basis as part of a change application because we don't have instructions to that. But in terms of steps, it'd be similar to what we've done before and what I've set out there. But in terms of timings and whether we'd even be able to do that, I don't have instructions. What I can run you through, though, is if it'd be useful, what we'd suggested as to how the thought experiment could be brought through the examination in addition to what's already been done, and to do that in a way that we consider to be procedurally sound. So I can do that. Just before I do, I suppose I want to make the point that if we were to follow a change application process for the thought experiment, as you just heard, one of the steps that would have to be determined as part of that process is whether those changes were to be material or not. That's something the EXB would have to consider. And I guess this comes to the merits of the thought experiment. But if at that stage the EXB were to consider that they are material and therefore they don't want to accept them, it's worth just reminding ourselves that the result and outcome of that is that the application that would then be put forward for the EXB to recommend on and the Council of Ministers to decide on would be the applicant's primary case with the larger parameters. It just wouldn't have the option with the applicant's minimum viable project as an alternative. It would just be the applicant's primary case, which is why we'd initially, in preparation for today, prepared another approach that doesn't need to go through that change request process.
That's understood, unless the examining body in the next couple of days or by Monday or Tuesday determines that the procedural route that it wishes to pursue is changes to Scheme 1 be brought forward through changes to the draft MIC, but any changes to Scheme 2 thought experiment be brought forward through that option type change request, in which case your primary case is essentially the changed MIC.
That's correct. Yeah, that's correct.
So then the option before us is Scheme 1 plus Scheme 2 coming forward as a change request, or just Scheme 1 already embedded in the draft MIC.
That's correct, yep.
Okay, so here's what I'm going to do. We're running out of time. I do want to hand over to Mr. Smith. Since you've got all this prepared, can you submit all of these different routes to us as a hearing submission by Monday? And I think all our hearing actions are going out on Monday, so we will take some of this on board. I appreciate that you don't have instruction on what you can do with respect to Scheme 2 being brought forward as a change request, but if you can put that process down, and I appreciate it'll be largely along the same lines, but just think through everything that we had to go through for Portskillion, where we did have to come back to you with at least 2, maybe even 3 Reg 31 requests for more information. So just think about that, and just prepare in your mind that if we were to go down Scheme 2 thought experiment as a change request, what it is that you'll need to prepare to submit to us by what you've quite correctly called procedural deadline, Friday the 23rd or 4th, whatever it is, yeah? Is that okay?
Toby, it's on behalf of the applicant. That's understood. We'll get that submitted.
That's amazing. Okay, any further questions from my colleagues? Any thoughts from parties around the table? Yep, and we've got Mrs. Strafford.
Hello, Ian Strafford. Sorry, Madam Chair, I didn't want to interrupt your flow, but there was something I just wanted to put into the examination when we were having the previous discussion around extension of the Paris Climate Agreement to the Isle of Man,
okay,
which I think is important.
Yes, yes.
So there was a freedom of information request made to the Isle of Man government, and as part of that, a Council of Ministers paper which went on the 22nd of December 2022, which is obviously post the Climate Change Act, was considered by the Council of Ministers. I won't go through it all, but the DEFRA Minister made 6 key bullet points. The last 2, I believe, are relevant, and they are simply: the Isle of Man will not be subject to penalties or sanctions if commitments are not reached. And the second one is the Isle of Man can withdraw should the agreement no longer be considered suitable. The reason I raise those 2 points is whilst it is a noble and moral ambition for the Isle of Man to meet those requirements, it is clear that in the future it is not a long-term legally binding position for us to be in should we choose that is no longer the correct thing for the island to do for whatever reason.
Okay.
And I think that has bearing again on the weight to be applied as to whether or not this is a strictly legally binding thing that we must meet, as opposed to something which we are choosing to meet but we can choose to exit if we wish to.
Yeah.
Okay.
Mrs. Strafford, that's helpful. I just want to turn to DEFRA colleagues here. A statement like that, if it's made by a DEFRA minister, what weight does it carry? Is it a written ministerial statement? Is it the equivalent of a WMS in England? Because a WMS will carry weight in policy consideration for an examining body. And so if it is, then I think it would be helpful to have that in examination.
Ken Milne, representing DEFRA. I think I would have to see the reference it's been referred to. I'm not exactly sure if it's going to be submitted, but the Minister represents the department. She is the department if it's in Tynwald. So,
Mrs. Strafford, if you give that reference, we will ask DEFRA to provide that into examination.
Sure. The reference is paper number 2022/663. And as I say, it was considered by the Council of Ministers on the 22nd of December 22.
So it's 2022/663, and it was submitted to the Council of Ministers on the 22nd of December 2022. Was it an FOI? No, you made an FOI request, but this is basically DEFRA Minister.
It's a Council of Ministers paper, so it's an official Comin paper. The Freedom of Information request number, excuse me, not with my glasses on, is 469969, and that's a part of the information that was provided under that Freedom of Information request.
Is there a title to the paper, or is it just meeting minutes?
No, the paper has a title, and the specific title is Extension of Ratification of the Paris Climate Agreement to the Isle of Man. So it was a specific paper considering that aspect.
Amy Stelling, on behalf of the applicant, if I may, Madam, we're happy to also take this action as well, but also one, I think, for DEFRA, is to understand the status of the Paris Agreement and how it applies in the Isle of Man. Certainly, I understand the Paris Agreement, albeit on an international law basis, which member states can withdraw from. That is true. To be a legally binding treaty, certainly the Isle of Man government website refers to it as a legally binding treaty, and it talks about how seriously the Isle of Man takes its obligations on climate change in response to ratifying this treaty via the UK, because at some point in the future the Isle of Man may leave the Paris Agreement. If that's the suggestion, I'm not sure that is something that you should be placing weight on, but I think the first step is to understand the status of the Paris Agreement in law and policy in the Isle of Man. We're happy to deal with that in our updated planning statement, but I would also encourage the Isle of Man government to confirm.
Okay.
And it might be a nuance, but bearing in mind the respective constitutional functions of Isle of Man government vis-a-vis UK government in terms of the split between foreign affairs responsibility and domestic affairs responsibility, and therefore the carriage of responsibility for treaty powers, in terms of a withdrawal from a treaty, is that within power of the Isle of Man government, or is that a decision that would have to be made by UK government?
Amy Sterling, on behalf of the applicant, I don't know the answer to that question.
Nor indeed do we, which is why we're asking it. Mr. Milne, you probably do.
I don't have the answer. It's Ken Milne representing DEFA, but it's maybe a question you could put towards the Cabinet Office, External Relations, who deal with all our external matters.
The question is, just for clarity for the actions record, given that to understand the distinction in constitutional power between the United Kingdom government, which in principle carries responsibility for foreign affairs and treaty making and compliance with treaties, as against the Isle of Man government, which in principle carries the constitutional responsibility for home affairs and all related matters. And the reason why that is relevant is because there is a point, I guess, about which of those two entities, HM government for UK or Isle of Man government, is empowered to withdraw from an international obligation once it has been entered into.
So I can see that there's a web of actions there, and I'm assuming that we've got them all noted. But I think...
Reg 31.
Yeah, I think it's the Reg 31 Friday deadline. Just on the policy documents one, can I please request that government departments and applicants stay in touch on that, because it'll be, while it'll be really helpful to have all the policy documents, it'll be equally unhelpful to have all the policy documents twice. So, you know, let's have one version of the truth. So if applicants providing something, we don't need that again from Cabinet Office or other parties.
Amy Sterling, on behalf of the applicant, I think we had suggested we'd update our planning statement for deadline 7, which I would suggest, therefore, we can liaise with DEFA and Cabinet Office as to which documents they're submitting next Friday. Yes. Our planning statement can then supplement that bundle with anything which was not provided and cross-refer to the documents that the government has provided. I can go with what's available online, but I hope the government have better access to their own documents. So it would be good if they could submit them next Friday, and we can seek to supplement at deadline 7.
Yeah. Okay, that sounds good. Although my slight preference... okay, yeah, no, that's absolutely fine. I'm quite happy to leave it there. Sorry, we do have a hand. Ms. Clark?
Thank you, Janet Clark, Isle of Man resident. While we're talking about transboundary issues, something came to my attention, and that was that Ireland requested to be engaged in transboundary consultation, and that sadly the Isle of Man government abandoned that consultation without notice. I understand that Joe Parkins, principal stakeholder, submitted the evidence for hearing 9, but it wasn't mentioned yesterday or today. Can the examining body please confirm on the record that they've reviewed it?
Ms. Clark, do you think we could take that away?
Can I add one more point about it? It's just that Ireland's had previous concerns about that particular seabed area because of possible disturbance of legacy Sellafield-derived long-lived particles. So I just wonder how the examining body intend to reconcile this procedural deficit with its duty to assess the radiological health risk to the public, particularly those of us who understand the bioconcentration kinetics of those isotopes. We used to work in nuclear medicine.
Ms.
Thank you very
Clark,
much.
that particular submission I definitely have seen, and we will seek a response on that.
Thank you.
Thank you.
Thank you very much, Chair. Now, I'm going to just say two things to steer us through the remainder of the afternoon. Firstly, to flag that, as Ms. Sahai indicated, we are not proposing to take an afternoon break in the interests of hopefully liberating everybody for their journeys homewards, perhaps a little bit earlier than the otherwise previously understood end of the day. Secondly, I'm then going to cover just very briefly what I'm not going to be bringing into examination orally now, because on your agenda papers, item 7, funding and deliverability, in the interests of time, we have decided to set into written questions. And let me be 100% clear, in this examination process, there is no distinction of weight or process between a matter that is examined in writing and a matter that's examined orally. And so there's no diminution of the importance or effect of anything that anybody may bring forward as a consequence of those questions. And one of the obligations that places on our shoulders is that there will be more questions than there would otherwise have been, but that's how we'll deal with that. In terms then of what remains to be dealt with in the rest of this afternoon, you'll be conscious that in specific issue hearing 8, we did not deal orally with item 9 entitled Economic Effects, Employment and Skills, and I think it is important that we touch on that this afternoon, albeit that some of the nuanced matters and some matters of detail may also go to written questions. And then finally, on this agenda item, on this agenda, shown after the break at agenda item 8, decommissioning plan and provisions, I have a couple of questions on that item, and I think it's critically important, given the folk we have assembled in the room, that we don't end today's hearing without doing that job. So that gives you a brief roadmap of where I'm going. So if we can then turn up the agenda paper for specific issue hearing number 8 and item 9, and you'll be alive to the fact that that covers economic effects, employment and skills, and specifically questions on job creation on the Isle of Man and indeed elsewhere, skills, apprenticeships and training, and any other employment effects. So, having regard to a kind of summary of the background of this material, hopefully to push us quickly to the items that I then am seeking observations on. We've reviewed the latest Outline Employment and Skills Plan, which I'm going to abbreviate as OESP, and that's deadline 6, D6-057 or 058 for the track changes version. And we're conscious also of changes in Scheme 1 that are not accepted and so are not necessarily formally before us. But the proposition that, amongst other things, a platform would be reduced, so we go from 3 to 2, and that would reduce the scope to potentially deliver servicing from an offshore platform base. And so with regard to that, I would like the applicant to please summarise the latest position in terms of employment, job creation, skills requirements and any other employment effects in the Isle of Man, if that were to proceed, as distinct from the base case of if we were to remain with that offshore base still prospectively constructed and in operation?
Dr. Carroll, on behalf of the applicant, the platform that will be removed from the offshore is the accommodation and O&M base. The reason that that is being removed, it was first incorporated within the project design because it didn't negate or duplicate the operation and maintenance base on Isle of Man. What it allowed, what it facilitated was the O&M activity from the Isle of Man, Douglas base, to go out to the platform, and then from there to go on and service other Ørsted assets in the East Irish Sea. That function now we're removing. We no longer need that. There is no change to the operation and maintenance requirements of the project as a consequence of that. All operation and maintenance activities in and out of Douglas remain exactly the same as they were with or without that platform. It just is not now a staging post to go further on.
If it's not a staging post to go further on, are there any consequential economic effects in terms of there being prospectively fewer employees and or less activity and less expenditure that would be, in inverted commas, Isle of Man domiciled?
Dr. Carroll, on behalf of the applicant, no, there's no change to the baseline. It is exactly as it would be previously.
No change whatsoever to the baseline?
No change.
Okay. Yeah. What I would like then to do is just provide an opportunity for observations from relevant government departments. And I think DFE and Treasury's positions are prospectively relevant, but I will then come to DOI and indeed DEFA if they wish to comment. So DFE first, any observations on that?
Richard Oliphant for Department for Enterprise. The only comment we really have on the application to date is that these are not set in stone, these numbers.
Yeah, no, we're conscious of that.
Yeah, we're conscious of the fact that we can't guarantee the numbers until after the application has been decided. A lot of the wording within the responses we've had to our submission are may or could, so it's very difficult for us to make a determination on what the true economic output from the operation and maintenance base would be at this point. So any more detail that can be provided on that would be really useful.
Well, exploring that just briefly, is there a proposition that some of those mays or coulds should become will and should, and or any proposition that with increased security for any specific economic activity dimensions that there would be greater certainty of economic yield, which possibly then would be evaluated in benefits terms in a different manner?
Richard Oliphant from Department for Enterprise. No, that would be really, really useful. Clearly, we want to identify and understand the jobs, not just the number of jobs, but the type of jobs, because that has an important impact as well, in terms of how we might diversify our employment base. So understanding what those roles might be, the level of those roles, the technical expertise of those roles would be really useful. Well,
essentially, you have spoken into what was going to be my follow-up question. And so in the interests of time, I'm going to kind of broaden this and allow you to finish the point, because I had then, following the validation with the applicant around the question of whether there were economic effects bearing on baseline consequential on the Scheme 1 proposal that had been put in front of us, and we've heard the applicant on that point now, I was then going to essentially just say something that the applicant doesn't need to respond to, but which responses from around the rest of this table will be valued on, namely that Requirement 6 secures the provision of an ESP, the Employment and Skills Plan, that is substantially in accordance with the OESP. And then we get back into the discussion that you and I have just been having, which is it sufficiently robust? Is it sufficiently secure? Are there matters of fine-tuning or further statutory provision that might be required in order to, one, give relevant government instrumentalities on the Isle of Man a greater certainty of, I guess, forecast in terms of its potential economic yield as a scheme, and also possibly change the way that the examining body might look at benefit. So you already started to speak to that. Feel free to say, I've done it. And if you say that, we'll hand on.
Richard Oliphant from Department for Enterprise. I think you've articulated it very well in the way you've just described it. The level of employment that's directly captured locally, if the O&M base isn't located on the Isle of Man, will be limited. So it's really understanding where and how that base and how it's locked in to this design it will be delivered and when.
And
because
again,
there's a timescale element to this, of course, as well.
And again, at the risk of labouring the point, you are possibly urging on us the need to look at fine-tuning the levels of commitment there. Okay. Now, if I can ask the same of Treasury, and it may well be that you're in agreement. But just before I do, Mr. Parsons, who are you representing? Apologies again. I just need to make sure I do go to all of the right people.
Income Tax Division of Treasury.
Okay, excellent. So you're under the same umbrella with Mr. Platten.
Yes, Jonathan Platten for the Treasury. Just to follow on from the DFE comments, obviously from the start we've been discussing the economic impact, and the greatest part of that being the impact on government revenues, noting the uncertainties around employment and skills. Treasury's or government's general policy has been around revenue raising rather than around employment creation from offshore wind farms, and that's been reflected in the various policy documents. And as a result, just to kind of, for the benefit of the examination, the kind of scale of the overall government income being proposed is in the proposed development is in the region of something like 2,000, in excess of 2,000 median wage jobs. And that kind of gives a bit of illustration of the scale of the local employment opportunities against the overall government revenue opportunities.
Okay. Right. Now, thinking about the best order of movement here, I'm thinking that I might come actually via DEFA and Cabinet Office if they wish to make observations, and then Mr. Garden, I will come to you as essentially ring-holding department, and then I'll return it to the applicant for comment, having checked on the floor. Are DEFA in a position to speak on this? No. Do Cabinet Office wish to say anything?
Fiona Houghton on behalf of Cabinet Office. I don't think it would be appropriate for planning policy to comment on economic matters. I think that would very much fall in other departments.
Okay, fine. In which case, I'll just hand the chalice to DEFA.
Thank you. DOI, Robert Garden on behalf of the Department of Infrastructure. I think we've heard what the DFE have to say on this in terms of further certainty, probably particularly around an O&M base and numbers of jobs. We've seen what's in the planning statement in terms of benefits, but I think any certainty that can be added to that through the plan, and noting the department's role as effectively approving authority for that in due course is welcome from our perspective. Similar to the discussions yesterday around kind of ensuring mitigation is secured. I think similar principles here.
Okay. Right. Are there any observations from the floor? And I do see one. Madam, wait until the microphone comes.
Thank you. Julia Grigine, Laxey resident. I understand that you're talking about the jobs that the wind farm will create, but we haven't had that much about the jobs that will be lost because of the wind farm. So the impact on tourism, hospitality, the potential cruises that won't come. So will you balance that?
Yes. And I will at this point just return very briefly to specific issue hearing 8, where there was an exploration of tourism effects. Part of that was deferred into writing because, again, we found ourselves under time pressure, so there will be a question set on that very point. And rest assured that what we're trying to look at here is economic net benefit in the round. Okay, can I just return to the applicant if there are any observations that need to be made in response to... we've got... Apologies, we've got Mr. Henshaw, Gulf Commissioners.
Yes, hello. I seem to remember from the original published documents that there were a possibility of up to 30 jobs within the Vannin shoreside sort of operations on the quay. That's the only thing, the only figure I've ever seen, I think. But I believe there's a centre of excellence in Morecambe, and for Orsted, is that right? And if so, would then it be sort of disingenuous to say that there would be another centre here on the island for the Moor Vannin array? Is that right? Can Dr. Carroll answer that question?
I'll tell you what, Mr. Henshaw, I have one more detailed question. After we've been to the applicant on this point, and before we close out employment and skills plan, I do have another detailed question, and it will, interestingly, just touch on that. So why don't you wait until that one's flown out, and then if you think it's been done badly, I'll come back to you. Sorry, Dr. Carolan.
Dr. Keown, on behalf of the applicant, I think it's really important to clarify what is part of this application, and the operation and maintenance based on the 30 jobs that a lot of people have alluded to is not part of the application in front of the examination. The application is for the offshore wind farm and the landfall works at Groudle Bay only. So when we speak about employment and skills in relation to this project that is in consideration, it is only in relation to those parts that make landfall on the Isle of Man. So the outline employment and skills plan, it sets out a modest number of employment opportunities, because they're the only employment opportunities that need to be secured, if they need to be secured, in relation to the construction and operation of the TJB at Groudle. That's it. The operation and maintenance base is secured. It's a requirement of our agreement for lease, and it's subject to a separate application, and it's not something that we're relying on in terms of the benefit for this application. So just to be really clear on them things.
No, that's a very, very useful clarification, and I'll be frank, that has, changed my appreciation of what was being potentially sought to be committed to in that plan and secured by requirement 6. And that actually means that the amount of weight prospectively that might be accorded to those broader economic and employment benefits, in your own words, Dr. Carolan, is reduced. Is that fair?
Dr. Keown, on behalf of the applicant, it's fair to say that there's modest opportunity, yeah.
Yeah, okay. Right. I did, but I'm not going to come to you until I've finished the question. And I will now do that. And I'm going to move through it fairly quickly, given what Dr. Carolan has just said, because I'm conscious that, a percentage of small is still small. However, is there an employment requirement in the Isle of Man that is likely to give rise to specific support for a development of new skills in the workforce, supply chain or business development? And are those matters that need to be dealt with in either the outline ESP or, in due course, the detailed ESP secured to be provided under requirement 6? And if so, what, if any, steps are being taken to bring the skills, apprenticeships, or employment opportunities or business development dimensions forward? Now, given the comment that Dr. Carolan has just made, I suspect the answer to that is limited. So what I'm actually going to do is I'm actually going to go to the applicant first on this point, and if that is true, then I'll provide an opportunity for comment, and then, Mr. Henshaw, I will come back to you.
Toby Yates on behalf of the applicant. So what Dr. Carolan, I believe, is specifically referring to there was in relation to job creation and the number of jobs, given the quote of 30 jobs that was being referred to. So that discussion was around job creation, and the outline plan actually secures approximately 5 to 10 as an example of the number of jobs that are expected. So that's direct full-time employment during construction, and then approximately 5 to 10 direct and indirect during operation. So that's the commitment in relation to the proposed development. However, it's not appropriate to secure those fixed employment numbers themselves. They're given as approximations because the final employment outcomes will depend on various factors that the applicant just cannot guarantee. For example, procurement, contractor selection, detailed design, etc. Whilst the applicant can commit to steps to advertise jobs, for example, they can't commit to jobs actually being taken by Isle of Man residents, and that's why it's given as an approximation. Now, to come on to your point, which I think goes more broadly than just job creation, throughout the examination, the applicant has emphasised in its written submissions that the outline plan isn't simply just an employment plan focused on job numbers, and it's been updated at deadline 1, deadline 4, and most recently at deadline 6. So there has been an iterative process, and it's intended to be a framework for maximising wider socio-economic benefits, not just for job creation.
Exactly, and that's why I asked that the broadening question.
Yes,
including, skills, apprenticeships, business development, etc.
Yeah, so that's the context, completely aligned, and I suppose the applicant's position is that through the iterative process that's continued throughout examination, that is what the outline plan, as secured through requirement 6, does provide.
Okay, but in terms of specifics, its level of commitment is still relatively limited. Mr. Yates, is that something that you would disagree with or broadly adopt and agree the position that Dr. Caroline put forward?
Toby Yates on behalf of the applicant. I think the point, again, Dr. Caroline was making, that it's modest relative to the size of the development because it's focused on the onshore elements of that development as opposed to the large offshore wind farm. So I don't think that it was the point that it's not appropriate in scale in relation to the work that it's supposed to be focused on, which is the onshore element.
Yeah, no, that's clear. But again, to be clear for our purposes, that there would be a substantial labour force associated with offshore construction and that the bulk of that would come from other jurisdictions. And similarly, in O&M terms, once a scheme was operational, there would be a workforce that would come from other jurisdictions. Is that the case?
Apologies, could you repeat the question, please?
Sorry, yes, do continue, Dr. Caroline.
Sorry, could you repeat the question? Sorry, I was just...
Yeah, I was essentially then asking whichever was the appropriate person on your bench to give me a view on, firstly, the utilisation of a labour force from other jurisdictions in the Isle of Man in construction, and then secondly, and the extent of that broadly, and then, or the percentage of the overall workforce, and then the same question in relation to operation and maintenance.
Dr. Carroll, on behalf of the applicant, in relation to the construction phase will apply approximately about 2,000 people to construct the offshore wind farm. Most of those will be through the principal contracts that we establish for in terms of the construction of the wind farm, the foundations, the cables, all of that. Unfortunately, there's no suppliers working at that scale within the Isle of Man that could really bid for, and there'd be very little Isle of Man workforce capable, or no contractors really capable of bidding for that type of work. So we'd imagine that will be quite limited. There may be some people on the Isle of Man that work for English-based, Welsh-based marine contractors that work at a bigger scale, so there would be employment opportunities in that respect. In the operation and maintenance phase, we will be looking for about 30 skilled technical positions. We have now started our employment through the employment skills plan, looking at upskilling, looking at training opportunities to get people from secondary schools through STEM school and then into technical training so that they will come on and take those roles. So there's an opportunity for that. Then obviously the wider workforce in terms of maintaining, operating, cleaning and all of that, and all other associated services that will come from the local workforce. So that indirect part could well exceed the 30 full-time roles within the operation and maintenance space.
Ms. Pannell has a question.
I'm pleased that you've moved to the offshore employment of 2,000. I'd like to talk about that a little bit in terms of possibly with the departments around the bench tightening some language in the requirement or the plan around local employment, upskill and training for local people, and writing that into the commitments and therefore the construction contracts So I wonder if could be some work done around that, putting some commitments in on training, percentages of training, locals, upskilling, so that you start using local people on offshore construction. And also, where are these construction crews going to be sited? So 2,000 people, I'm assuming that's over the course, so that's the total amount of people. So the full-time equivalents must change over the course of the application, but they will need accommodation, food, services. So are you planning on locating those staff onshore? Are you talking about a construction camp? Or are you talking about using local hotels? So there's two things here. One, commitments around local workforce, upskills, training for these 2,000 people, writing those into the commitments and the documentation, but also in construction contracts. The second question is about housing and facilities for the people that you are employing.
Dr. Carr, on behalf of the applicant, is a very interesting area for conversation. It's offshore wind in its nature now is global. So in the procurement field, we are going out globally. So it could be the principal contractor could be from mainland Europe. They could be sailing out of Rotterdam. It could be cables be coming in from America. There could be foundations coming in from Taiwan. So it's split in many parts, and we don't really have control of that. It's a competitive tender process, so we have very little control over where that principal contractor chooses to be based, whether they want to come onto the Isle of Man, whether they have an offshore accommodation vessel. Most of them, so say if they were building in the North Sea, they'd come out of, say, one of the major ports like Rotterdam. They'd sail out, they'd have all of the accommodation, they have flotels, so they're just out there permanently, and they very rarely touch shore. So some people then on leave will come on shore, but that could be for, like, say, a week, every 3 weeks. So we have very little control over that in terms of our state, so it's up to the principal contractor. So that's why it's really difficult for us to pin down what the benefits are.
I understand you can't pin down the benefits, but do you not write the invitations to tender? Ulster doesn't write those. They're not in control of them.
We write the invitations to tender,
Okay.
but we don't specify that you must house everybody in the Isle of Man and spend
No.
£500 a month.
That's not what I'm asking. I asked whether you write the invitations to tender.
Of course, yeah, we
Okay.
write the invitations to tender.
So
yeah.
you write the invitations to tender. You're guests of the Isle of Man while you construct it. So I'm asking if there's possible to have a conversation with the government departments on offshore staffing and whether there's an element or some kind of work that can be done on local staff training and some commitments around that. I'm not saying 2,000 people have to come from the Isle of Man, but there might be a proportion or an opportunity for the Isle of Man to use local people. And the second thing is some more words around, I mean, they're not going to stay on an island in the sea for the entire duration. They will come on to the Isle of Man for some things. So some conversations around that and whether there's any possibility of building that into the process.
Dr. Kieran, they may come on and that will be wholly their choice and not something that we have influence over. The employment and skills plan, basically, the employment and skills plan sets out what we're going to try and do in terms of skills, in terms of local workforce, how we wish to develop that local workforce and give them opportunities, how we wish to collaborate with a local organisation, develop a skills pipeline, signpost for local organisations how they can be involved in that competitive tender process and for us to support them through that, and how they can help get involved with the operational phase. We've got an education, skills and employment strategy, and we also have an Isle of Man supply chain process which is active live on the Ørsted website, in which we're already reaching out to those organisations and seeking that early engagement for the upskilling and training. But we don't really have control on the final numbers, but we're giving it our best. You know,
Okay.
we agree and we're supportive and we want as much benefit to the Isle of Man to flow out of this project, but in a way we're limited on what we can control.
I think you just said in that, the text that you've just said about talking to the Isle of Man governor about the tenders, so that was my point in the beginning in the first place. I'll hand over to my colleague now.
Okay. I'm acutely conscious that I opened that position with the applicant because of the previous submission that we've had, but what I do want to do, and in fairness has to be done, is then to ask if there are observations that DFE, Treasury and DOI wish to make on that point. And I'm taking it again that DEFRA and Cabinet Office probably will not wish to speak on this item. And I did promise, because I said that we would deal with this issue, Mr. Henshaw, Gulf Commissioner, has the opportunity to come in as well. So can I just check, Treasury, any further observations? Sorry, I was going to go to DFE first. Apologies. No, DFE, any further observations?
Richard Oliphant from Department for Enterprise. The only point of reference we really have when looking at this is operational bases in Wales and in Barrow-in-Furness. And when we've looked at those, the numbers are in the low hundreds in terms of people that are employed within those bases. Whilst we appreciate that the island may not be skilled and ready to support operational maintenance of such a offshore wind farm, it doesn't mean that those jobs could not be secured and located on the Isle of Man and fulfilled by people outside the Isle of Man for now, whilst the skills and workforce project was underway, which would bring those people up to the standard they need to be. So some sort of commitment to locate those roles here in an initial instance would be useful.
Noted. Yeah. Okay. I'm then going to go to Treasury.
Toby, it's on behalf of the applicant. Sorry, if I can just come in before you go.
Well, I'm going to come to you at the end for everything.
That's fine.
Yeah, just to make a comment from David Parsons, Treasury. From an income tax perspective, during the construction phase, if there is a large volume of workers working in Manx territorial waters, depending upon exact circumstances, it's likely that there will be Manx income tax revenue in respect of at least a proportion of those workers.
Okay.
Jonathan Platten for the Treasury. Just to clarify, I think that 2,000 figure that you referred to just now, I think possibly I didn't explain that very well. What I was trying to do is put into context the overall policy around revenue generation from these offshore wind farms. I was saying it was equivalent to around 2,000 median wage workers in terms of the kind of annual income, rather than it would generate 2,000 jobs.
I was clear on that, but thank you for clarifying. Yeah.
So yeah, just to put that in context, and that has informed the government policy that has been set out here.
Okay, I'm going to come to Mr. Garden, please.
Yeah, Robert Garden on behalf of the Department of Infrastructure. I think endorse what the panel has said and encourage DFE, I think, as the responsible body to take that forward with the applicant in terms of those jobs offshore. I think the only other initiative that comes to mind is engagement with Manx Utilities Authority, obviously as an energy provider on the island, responsible for electricity and potentially some work to be done there as well. But I think otherwise, yeah, I think as I said before, there is certainly more that we would like to see secured in the plan and engagement through DFE.
Okay. Now, I did say I would come to Mr. Henshaw, and it is his turn. So if the microphone can come to him.
Thank you, Mr. Smith, for drilling down into that point. Just to rewind a little from the initial first comments, one of the people there to the right of Amy did say that there was, in the initial reply, that there was 10 to 15 jobs or 5 to 10 jobs initially after the construction phase is completed. But if the examining board wants to take into consideration the pamphlet that was dropped through every letterbox in the Isle of Man to all Isle of Man residents, it clearly states here more than 30 full-time skilled jobs will be created in the Isle of Man once the project is operational. The offshore wind farm will lay the foundation for a lasting economic investment by developing local skills and creating new jobs. That's more than 30 full-time skilled jobs. Now, even Dr. Carolyn has just replied there that there would be possibly in cleaning and other industries equivalent of possibly up to 30 full-time jobs, but it's certainly not more than 30 full-time skilled jobs. So it does beg the question, if these people are coming in from UK and yes, they may be giving some tax revenue for some in their salaries. What is the situation as far as their status is concerned for work permits? Because that's also, it comes into the Manx territorial waters, I believe. So before I let go of the microphone, I'd just like to say that if the 30 jobs that were promised in the pamphlet are not actually realistic or being realised or actually materialising, then I'd like to add that to the number of disbenefits that the system is proposing. Thank you.
Thank you very much, Mr. Henshaw. And then, sir, I don't believe I can immediately recall your name, but there's a gentleman in a yellow shirt up here. So if you can introduce yourself.
Jamie Smith, Garth Commissioners. Mr. Henthorne stole my thunder on one of my 2 points, which was we have a work permit system, and I can't believe that the Treasury and Department of Enterprise are latching onto that as a tool that they can use to leverage in this situation. And I sincerely hope that the examining board body asks them their opinion on that. And the second point is that I also think there's Department of Enterprise may have missed an open goal. They've heard about floating hotels of workers in Manx waters, and I think they should be asking the tenders to include, so at least 50% of shore leave is spent in Douglas and the Isle of Man rather than Blackpool and Liverpool and things like that. And it's not personal to Mr. Oliphant, but I do believe our department isn't working sufficiently for us. They've got some open goals in front of them, and they're blazing it over the crossbar. And I know that's not a question, it's a statement.
It is a statement, and I think we must pull ourselves back and focus on the planning merits positions that have been articulated there. Now, we've heard those points, and I am going to seek a response now, Mr. Yates, in the round. I'm very conscious that I didn't introduce you before, but I didn't want this to become a kind of tic-tac. I wanted you to be able to think strategically and holistically about everything and then provide a response in the round.
Toby Yates on behalf of the applicant. That's fine, sir. It's mainly a point of clarification just to make sure everyone is absolutely clear. There's a distinction here between the figures that are being spoken about in relation to operation and then also the commitments that can or should be made in relation to construction. So the figure of at least 30 full-time workers, which has been mentioned and has caused some confusion, that derives from the wider whole project, so the operation and maintenance base, which will form part of the whole project, but isn't the subject of this marine infrastructure consent application. And that's why at deadline 4, the outline employment and skills plan was updated to remove reference to that figure, because it's not a figure being committed in relation to this consent application. It's a figure that's relevant for the wider project. The figures that are relevant for this application, as I set out before, are the approximations of the 5 to 10 full-time workers for operation and then 5 to 10 prior to that during construction. So it's just to make that point of clarification that the majority of jobs during the operational and maintenance phase arise in relation to the operational and maintenance base, which is outside of this application. So that was a point of clarification. Second point in relation to the construction activity that Dr. Caroline was talking about in more detail before, as I explained, we can't, or the applicant can't commit to specific job numbers for the reasons I set out, but of course we welcome further discussions with other stakeholders to see what additional detail potentially could be included in the outline plan. And as I said before, that's a process that the applicant has already been engaging with, as has been set out in the updates that have come during examination.
Thank you very much, Mr. Yates. Now, what I'm going to suggest is that we make some of this concrete in the form of an action, because we've heard a clearly articulated view from Department for Enterprise that it would be desirable that there was a more concrete statement of employment, skills, training and related economic yield and benefit, and that it would broadly be desirable that it was more precisely secured than it is currently in the outline ESP as it exists. So I'm afraid we are on a bit of a timescale here, and so I am going to suggest that by the Regulation 31 deadline, which will be a week today, that principally DFE as lead, if I'm correct, department in this area, sets out its asks. What are the dimensions of additional provision that it might seek in the OESP? What additional security might it seek for dimensions of those, particularly focused on the delivery of employment within, skills within, economic benefit within, training within, business development within the Isle of Man, and why? and how those might be secured. There may be related matters that could usefully be addressed in that submission, including the interface between Isle of Man Water's employment and the work permit system and the taxation system, because if there are to be workers employed in Isle of Man Waters, and as a matter of law they will need work permits, and as a matter of law they will pay Isle of Man tax, then there are yields there that may be directly consequent on the consent that might need also to be taken into account. But without those figures in front of us, or without a methodology to take that into account, we can't take it into account. So that's the ask that I'm making, principally of DfE. Would you mind ring-holding that on the basis that if other government bodies wish to have a position in that, they would come via yourselves? Yeah, I see a nod, and I see a nod also from DOI. So it feels as though we've got a clear and simple way of getting that additional position into the examination, which then leaves deadline 7 for the applicant to reflect on the question of whether there are any further changes to either the OESP or the requirement in terms of what might actively be secured, or alternatively it is your remaining view that your final position is as stated and there are none and none, although then, and I will just float this out for literally 2-word observations, if no further changes to the OESP and the level of security for it are made, what are the final observations on weight to be accorded to employment skills, training and related benefits? Very brief observations from any of the government instrumentalities. I think we've probably already said in terms what you think the answer to that question is, but before we close this down, I'd just like to check final words. Any final words from the floor? No, no. So, Mr. Yates, finally, in response.
Toby Yates on behalf of the applicant. It's just to confirm the applicant's position set out in its planning statement, which is D4-034. I appreciate that will be updated, but in relation to employment, it sets out, for example, there's a slight beneficial effect on employment across all 3 phases of development, and that makes reference to the 5 to 10 figure. It goes into more detail than that, but just to signpost, that's where the applicant's position is.
Yep, no, that's clear. Okay, in which case, unless there is anything else that any of my colleagues want to raise on that item, I'm going to move to what I believe is the last substantive item, which is to touch on the decommissioning plan, the decommissioning process and relevant provisions. And the 2 items which I'm essentially going to run in together are the extent to which a plan and process for decommissioning the proposed development has been provided for and is sufficiently certain, and then specifically whether MIC requirement 7 and the outline decommissioning plan, and I'm there going to refer to the documents APP-209, D4-093 and 094, frame and secure an appropriate decommissioning process and actions. Now, what I'm going to start by doing then is just summarising the position articulated by a number of the principal stakeholders in various written and oral representations in the examination to date. And these have raised concerns about the extent to which the decommissioning process is financially secured, and that essentially at the point where decommissioning needs to occur, that there is an entity of sufficient financial means to give effect to the decommissioning works. That the question of when it's anticipated a detailed plan pursuant to the outline decommissioning plan and decommissioning programme will be submitted and approved, whether the timing of that process is clear and appropriate, and whether the relationships between the outline decommissioning plan, the decommissioning programme, and then the final decommissioning plan are also sufficiently clear, robust, deliverable, and if needs be, enforceable. And to provide a focus there, before I open this up to the floor, clearly the outline decommissioning plan, D4093 and 4 frames a decommissioning process, and MIC Requirement 7 secures it. And it's worth reminding ourselves that Requirement 7.1 provides that no offshore works may commence until a written decommissioning programme has been submitted to the department. Requirement 7.2 then provides that a decommissioning programme must include the details of the decommissioning measures, an estimate of decommissioning expenditure, a means to decide when the measures would be delivered, and details of the proposed security measures, which could include a parent company guarantee, a letter of credit, or other suitable form of security. So, to a substantial degree, secured on the face of the order is, at least apparently, a form of framing out the detail for decommissioning at the right time, in inverted commas, and setting out security for the financial dimensions of it, whilst at the same time making sure that the offshore works do not commence until that has been done. So that is a very robust piece of drafting in its apparent operation. However, Requirement 7.3 then provides that within 6 months of the permanent cessation of operation of the authorised project, a decommissioning plan, which must be substantially in accordance with the outline decommissioning plan, must be submitted to the department for approval, unless otherwise agreed by the department. Now, there's a disjuncture there between the detail which is set out in the Requirement 7.2 decommissioning programme, which has very clear objectives, targets, and a security, a financial security written into it, and the general accordance provision in Requirement 7.3, which takes us back to the beginning of the process and requires general accordance with an outline decommissioning plan, which by that point ought to be a matter of history. It's gone. The thing that is in place now at this point, after works have commenced, is the programme. But Requirement 7.3 apparently does not secure general accordance with, by that point, the approved programme. And it is the programme that sets out the levels of financial security, etc., which are sought by the number of principal stakeholders, written and oral submissions, and the matters that folk have sought clarity on. So what I'm going to do is I'm going to throw that open initially to observations from the government departments. I'm then going to go to the floor, and then I'll finally come to the applicant for a response. I think this is probably best first going to Department of Infrastructure. So, yeah. Mr. Garden.
Thank you, sir. Robert Garden on behalf of the Department of Infrastructure. I think your thought process has probably followed our thought process before this hearing, and we've been engaged with the applicant on potential further drafting. In relation to the decommissioning programme, the content of that is intended to reflect the equivalent process in the UK, so the Energy Act 2004, and the provisions there. What we are proposing to propose to the applicant and will engage with is effectively a right of approval in relation to that decommissioning programme, and then retention of that programme throughout the life of the project, with review periods so that it operates in a similar way to that Energy Act decommissioning programme piece. And as you say, that piece secures the financial security and the means of effectively implementing the decommissioning programme so that will be in operation. The decommissioning plan, I think, is still important to retain in the draft MIC, because that operates slightly differently and is intended to be the how, if you like, the how the applicant actually gets on and decommissions when that is established at a point in time in the future. And as you say, we don't have that position at the moment, so we can't set out in detail the precise requirements as to how decommissioning will take place. So that is the intention between, or the difference between the programme and the plan, and why the programme is probably more specific at this stage than the plan. But I think with the additional wording that we're looking to agree with the applicant, that should provide the extra security I think that you're looking for in that requirement.
Thank you very much. Can I ask you also then just to turn your mind to the interface between that provision and Requirements 7 and Article 6, the benefit of the order and the provisions around transfer of benefit? Because I would not like it to go undiscussed that clearly one of the circumstances around any form of financial security or formal commitment in relation to future actions to be done would be that any future action committed to by the undertaker at any given point, should a transfer of benefit occur and be consented, there needs to be absolutely concretely clear that the transferee is bound fully by the obligations of the transferor. Now, I think, reading it, it probably does that. But there are many good minds around this table, and I wanted to make sure that we were all agreed that that was so.
Yeah, Robert Garden on behalf of the Department of Infrastructure. That is how it's intended to operate. We will double check again, but the intention, one of the reasons we have pushed for the approval piece in relation to Article 6 is tied effectively to decommissioning and the need for that to continue to be secured.
Okay. Are there any augmenting positions that any of the other government departments or bodies want to put on this point? Yes, I do see Mr. Milne for DEFRA.
Ken Milne, representing DEFRA. Just the one point to make in the Marine Infrastructure Consent, obviously just makes reference to the Department of Infrastructure. Given the potential environmental, health and safety implications, we also ask that DEFRA be included as a consultee there as well. Thank you.
Okay. Now, I'm thinking about the best way to bring this forward. I mean, there clearly have been some conversations between DOI and applicant on the drafting of this point. My sense would be that maybe this is something that probably doesn't need a specific action, because I'm very conscious we've got the action list from the 7th circle of hell at present. It's got a lot of stuff on it. But we are going to issue a commentary on the draft MIC, and it may be sufficient that we identify this item in the commentary. We know what we've spoken about because we've spoken about it, and the relevant parties pick it up in their responses to the commentary, which then gives the applicant the opportunity to put in a final preferred draft MIC, taking account of points that have been put, and that would deal with Mr. Milne's point, and it would deal, Mr. Garden, with your points. I'll reflect on that after I've heard the applicant, but before I go to the applicant, I will just finally check the floor. Are there any observations on this point? Or I see one hand. And I'll make clear that, you know, having seen one hand, I'll introduce you, sir, but then I'll close the item.
Okay, thank you. My name's David Owens. I'm an Isle of Man resident. It's just a very quick point. In the UK Act, do we not have a decommissioner of last resort, which is the UK government? And if so, would that have the equivalent in the Isle of Man?
Actually, that is an interesting point that has arisen in a number of the submissions. This a fear, if I could probably characterise it in simple terms, that somehow or other, following the cessation of operation of the authorised development, the liability, the full financial liability for decommissioning would somehow fall upon the shoulders of the Manx taxpayer as a decommissioner of last resort. So I'd really welcome the applicant picking that one up in their final remark, and if in fact there's anything that DOI wish.
As a chartered accountant, I was hoping to challenge the assumptions in the forecast projections, which is item 7. Can I now submit a written request on that?
Yes, because item 7, which I have indicated to you will go to writing, there will be written questions, and you're as welcome as anybody to make a response to those questions. So, Ms. Sterling, can I come to you or Mr. Yates?
Toby Yates on behalf of the applicant. So I'll take each in turn. Firstly, just to confirm what Mr. Garden said, that's the applicant's intention around the split of the purpose for the decommissioning programme and then the decommissioning plan, and we can provide updated MIC wording as Mr. Garden suggested. Next, I think the point was around the benefits of the order, and just to confirm, if you look at Article 6, subparagraph 4, subparagraph C of the draft MIC, that confirms, and I'll read verbatim, the exercise by a person of any benefits or right conferred in accordance with any transfer or grant under paragraph 2. So what that means is where someone is transferred the powers of the MIC, it is subject to the same restrictions, liabilities and obligations as would apply under this order if those benefits or rights were exercised by the undertaker. So that ensures that requirement 7 decommissioning would also be applicable to a transferee.
That was my reading of it. So unless this is a reading of the bans on that point, unless anybody specifically disagrees, it feels as though that item has been secured.
Thank you, sir. And then the next point was in response to DEFA and the request to be a named consultee, and to confirm the applicant is comfortable to make DEFA a named consultee in respect of the environmental matters only. The hesitance so far has been that the outline plan or the final plan that will be submitted will go broader than that and beyond what the applicant would consider necessary for DEFA to be consulted on. So we can discuss with DEFA and consider some wording to secure that. And I suppose to confirm, the position to date has been that in absence of being a named consultee, this is applicable for the decommissioning requirement and all other requirements. There's nothing stopping the Department of Infrastructure as the approving body from consulting with DEFA or any other body it considers appropriate in discharging a requirement, but we'll take that one away as part of our updates to the drafting. And then the final point that was just raised there in relation to liability for decommissioning, the applicant submitted a written response in relation to this. I believe it was Garth commissioners that have previously raised this in writing as well. A reference there for those interested is D4-004. Forgive me for all the numbers, but the response there is response to D3-031-007. So that's the initial submission that was made by Garth, and the deadline for document was the applicant's response to that. And what that sets out in summary terms is that the financial security for decommissioning is secured via the requirement for a guarantor, which is in the draft in the agreement for lease.
But interestingly, is also secured in relation to the decommissioning programme itself on the face of the order. So it's belt and braces to a degree.
Toby Yates on behalf of the applicant. That's correct. I suppose just to make sure everyone's clear on the scope of what requirement 7 subparagraph 2 secures, it's that the decommissioning programme must include details of proposed security arrangements which may consist of a parent company guarantee letter of credit, etc. So it's not a firm commitment to the type of security that will actually be secured, but you're correct, sir, that is supplementary to other commitments in respect to a guarantor that are captured as part of the agreement for lease.
And given the public interest in this, and that the AFL is not a in principle publicly available document, whereas the made order, if it were to be made, absolutely would be, there is possibly an argument for, rather than a verbatim equivalent commitment in the face of requirement 7.
Amy Stirling on behalf of the applicant. I don't think it is a may. It says the decommissioning programme must include, and so I think I would suggest that it must include financial security.
Yes, we may have misled each other by busking on the words there, Mr. Yates. I'm just turning up the actual drafting now. Just bear with me a second. Must include, yes, no, that is absolutely correct. But no, it's a may and a must, because it's paragraph 2 followed by subparagraph D, which in terms of the details, which may consist of.
Amy Stirling on behalf of the applicant. It must include proposed security. It must include security arrangements, which may include the forms of security which are listed. I think the distinction perhaps that Mr. Yates was making is that here you've got the, it's essentially for the department to approve, or it will be when we've updated the requirement, the appropriate form of security. In relation to the agreement for lease, that's already been determined, and there's a guarantee available under the agreement for lease, whereas this requirement drafting provides an opportunity for the department to approve the suitable form of security, whether that's a parent company guarantee, letter of credit, or other appropriate arrangement, but it must include security arrangements, the form of those.
Yeah, no, we're clear, we're agreed. There must be security, but it has a portfolio of options to take different types of security, but there must be. I do see Ms. Clark's hand has just risen, but what I am going to indicate, as I did, Ms. Clark, before you raised your hand, is that in principle I have now closed out oral responses on this item because I had gone to the applicant for its conclusion. So, Ms. Clark, I will hear you very briefly, then I will return to the applicant, and then the item is closed.
Thank you very much. I just wanted to mention that the guarantor is Ørsted themselves, basically the parent company. I don't know if that came across or not. Thank you.
Noted, although equivalently there are other forms of security that the requirement 7.2 enables, and if the Isle of Man were to be sufficiently concerned at the relevant point, it could seek a form of security other than a parent company guarantee.
Yeah, Robert Garden on behalf of the Department of Infrastructure. That's correct, and we're obviously also looking at building in potentially the review process that you have from the Energy Act, so it's not a one point in time obligation.
And that is also a very clearly made point. Unless anybody else has anything further to raise on this point, I'm just checking with my colleagues, mindful that again this is the last substantive item on this agenda. Madam, this is, I am very serious now, this is the last interjection I will take. I've already indicated that I was going to close the item. Now, let's just, very briefly.
Very briefly. Basically, I think what the majority of the Manx public who are looking at this and are concerned about is, are our children, our grandchildren going to be left with a massive bill because we messed up in this arrangement at the beginning? And so the question really would be, is being cynical, what would happen if there was a total insolvency on the individual or the company that was actually operating the wind farm at the point that it became insolvent, and who would be left to clear that up then? Under the 2004 UK Energy Act, I believe the final backstop on those sorts of things is the UK government, who would step in and sort that out. But I don't see that the Isle of Man government would have the wherewithal to be able to clear up what would be left in our seas. It would fall on the taxpayer.
I'll return very briefly to Mr. Garden, and I don't believe this engages the applicant, because in that hypothetical the applicant doesn't exist. Mr. Garden.
Yeah, Robert Garden on behalf of the Department of Infrastructure. The purpose behind the security is so that if the applicant, for whatever reason, were unable to fulfil its obligations, there would be somebody sat behind it, a guarantor, the Ørsted parent company, or potentially another entity to deal with that. So that is the intention behind the drafting. So there would always be a kind of security provision there. And again, that's the rationale behind the review process that we're looking to include, is that is not just dealt with today and left, it's kept under review during the operation of the wind farm.
Is it worth observing, for the benefit of members of the public interested in this, that there are mechanisms around this form of provision that amount to a kind of analogue to an insurance, where a third-party body can take an obligation as a commercial thing for fee, so to speak, and the balance of risk or benefit is then something that the Isle of Man thinks about when it thinks about what the appropriate form of security is. Mr. Garden.
Yeah, Robert Garden on behalf of the Department of Infrastructure. I think it's something I need to take away, but there are those products out there that exist, so there are ways of ensuring things like this.
Okay, we must now close this item. So, ladies and gentlemen, thank you very much for your contributions, and I'll hand back to the Chair.
Thank you very much. I'm not going to hold anyone any longer, but just a reminder that the hearing actions will be issued on Monday. They will be issued under the banner of a Reg 31 so that we can include an additional deadline. Applicant, I would encourage you to think about how you're going to submit the signed SOCGs at deadline 8. We would like to see some kind of corroboration from the other party that this is the final version, whether that's ink on the page or something else, then do please think about that. One matter that we've not ticked off is coordinates on the location plan. Typically in a DCO examination, I'd have some other party corroborate those coordinates and that they're correct. In this, I think that would be the Department of Infrastructure, I believe. So that action will probably be issued separately on Monday as well. Correct?
Yeah, Rob Gunn on behalf of Department of Infrastructure. Yeah, I think we'll look at that. Might be Friday.
That might be
Friday.
Yeah, that's fine. We will issue it on Monday, but yeah, that's fine. And I believe that is it. I don't think there's anything. Yeah, no, there's nothing else remaining. So thank you very much for your contribution. Please don't forget the examination has not closed. This is just the last hearing. The examination remains open till the 9th of September. Please follow the examination timetable and we hope to keep hearing from you. The time now is 4:46 p.m. and I am closing specific issue hearing 10.